Okay, we are here on the Senate Committee on Judiciary C, September 5th. Madam Secretary, would you call the roll, please?
Senator Morris?
Here.
Here. Senator Abraham?
Here.
Here. Senator Barrow? Senator Cloud? Here. Here. Senator Hodges? Here. Here. Senator Kleinpeter? Here. Here. Senator Miguez? Here. Here. We have 6 here.
6 and a quorum. Thank you, Madam Secretary. Has everybody a chance to review the minutes of the last meeting? Senator Abraham moves to approve the minutes of August 7th. Any objection? So the minutes will be approved. A couple of just a little announcements first. First of all, I think I've already mentioned we have a overflow room, AB, so feel free if your colleagues come in and they don't have a place to sit, they can go next door. We are joined today by Senator Royce Duplessis. Senator Barrow could not be here, and so he is joining us, and we're happy to have him. Lastly, we will be having the public will have an opportunity to speak. However, we're going to limit it as we have a number of witnesses who have been asked to come. So if you are seeking to speak, please fill out a card, regardless of whether you were asked or not asked. And if I would suspect you should probably all fill out a white card, as there is no legislation pending before this. This is merely an oversight hearing. We're looking to delve into the facts of some issues that have come to light, and at some point there may be a policy response, but nothing of the sort is happening today. With that being said, we'll get started, and the first thing on the agenda is a presentation by our Attorney General, Liz Murrill, and General Murrill, if you want to come to the table and give us your presentation on post-conviction relief, which is the subject we're trying to understand.
Thank you, Mr. Chairman and members of the committee, for allowing me to talk to you a little bit before we start this discussion about what the process is for post-conviction relief and for what I'll call repeatedly subsequent petitions for post-conviction relief, which is where most of these cases come up in our discussion. So I handed out a little diagram. And I'm going to reference that diagram because I want you to be able to see where the case starts in the criminal justice system and then where it goes after conviction through the appellate review process. And we'll just kind of walk through that pretty quickly. So every case starts with charges and a trial or guilty plea. And that entitles someone to a right to appeal on direct review. So that's the initial column that you see where they can take issues up and take them to the state court of appeal, First, Second, Third, Fourth, Fifth Circuit courts of appeal. Sometimes issues get up there during the trial, but this is going to be after the trial. And then they can go to the Supreme Court. And they can appeal the same issues that they brought up at the Court of Appeal in the Intermediate Court of Appeal. They can take up at the Louisiana Supreme Court. That's a supervisory relief court. So they may take the case. They may just affirm the judgments. They may deny the writ and say, Court of Appeal, you did a good job. They then have the opportunity at that point to go to the United States Supreme Court and file a cert petition on direct review. Again, that's discretionary at the United States Supreme Court. Most of those cases don't get relief. Sometimes they do, but most of them don't. After that, the defendant under state law is entitled to go through a process called state post-conviction relief. That's a process that the legislature has afforded defendants in the criminal justice system, but it's not legally required by federal constitutional law. We do that as a matter of legislative decision and legislative grace in the criminal justice system, where they can go back into the state system and raise certain issues on post-conviction relief. We call it state habeas. It's technically a civil proceeding. The person is challenging they're being held in a prison, and they're challenging usually certain constitutional issues that they think were defects in the proceeding. That may be where they're bringing up ineffective assistance of counsel, usually in that stage, because you wouldn't be able to do it before that. So that process starts all over again. You file it in district court, the judge makes a ruling, you can take it up to the Court of Appeal, and then you can take it up again to the Louisiana Supreme Court. Those cases don't go to the United States Supreme Court. They just, at that point, you can go to federal court, and you have a right to federal habeas. So now you can file your appeal in the federal court and raise questions of federal constitutional law in federal court. In both of these proceedings, in state habeas or in federal habeas, there are procedural restrictions. There are limits in the law in terms of the time that you have to bring the petition and the claims that you can bring. So that's all on the state post-conviction relief, a product of, it's all in the state code of criminal procedure. In federal law, it's matter of federal law. A lot of federal habeas law is jurisprudential. So a lot of that happens in the courts, district courts. So they'll file a petition there, and then they can ask, they have certain ability to seek relief in the United States Fifth Circuit Court of Appeal, and then they can go back up to the United States Supreme Court in federal habeas. Federal habeas is very limited. There's a federal statute that requires deference to be given to state judicial decisions that have been made on issues that were raised already. So there's some deference given to that judicial review at the state level under a federal statute that applies once they're in that stage of the proceeding. After that, they have the ability to go to the governor and seek clemency through the Board of Pardons or a commutation of the sentence. So that is really sort of the whole process that somebody that's been convicted of a crime in our criminal justice system. That's the path that they can take, and that, I think, kind of illustrates how many judges they're going to see in that process in that first round. So we also have a statute that allows for subsequent petitions for post-conviction relief. So what we're really going to be talking about today are predominantly convictions that are being revisited in a subsequent petition for post-conviction relief. In some cases, it's the third. It may even be a third petition, because we don't have a limit on the number of times that you can file a repetitive petition for post-conviction relief, but we do have pretty strict limits on what the basis for relief is for a subsequent petition for post-conviction relief. And I can, I have a few cases. I know that, and I've made public statements that I'm going back and looking at a number of the cases that occurred in Orleans Parish, because there's a disproportionately higher number of cases that have been granted relief in Orleans Parish, substantially higher compared to every other district attorney in the state. And so when that discussion arose, I said I want to see exactly what's happening in these cases. So I've taken the cases from January to July. I picked January because that's when I got inaugurated. So I'm going from January to July 31st, when we changed the law. So you did make a change in the law in the criminal session, and that change affects subsequent petitions for post-conviction relief. It clarifies that the restrictions on that petition are jurisdictional, that they limit the court, and that the court has to look and make sure that these restrictions have been met when that petition is filed, and that those are not waivable by the district attorney. So that places some responsibility in the hands of the court to ensure that the restrictions that the legislature put in the statute are met. And it also allows the Attorney General, requires service on the Attorney General of the initial petition, and it allows me to intervene, or any Attorney General to intervene if they believe that that is appropriate under the circumstances, and defend the conviction. And so what I'm doing now is I'm taking a look at all of those cases where relief was granted by a court in a case where there were no procedural objections asserted. So it's been my opinion that the restrictions in the statute are jurisdictional, but there are some that are considered procedural, and the statute, quite frankly, doesn't say which is which. It does now. It says that all the restrictions in subsequent petitions for post-conviction relief are jurisdictional. So that was a good clarification, I believe, that occurred in the law. There's a lot of testimony about it. I can tell you that in a case that involves actual innocence, those restrictions don't apply. You can always bring that case where it involves a claim of actual innocence. So I think that the restrictions that we brought, that the changes that you made are important changes that have occurred, but you do I think it's going to be a good process that we go through to kind of look at what's happening in these cases so that you understand better what occurs in all of these cases and why that was an important change to the law, and can consider any additional ones that you might want to make. And I'll take any questions that you have.
Thank you, Attorney General Murrell. A quick question for you. Out of the cases that you've reviewed thus far, and we've reviewed and our staff has reviewed some of the same cases, and there's been a little bit of a delay getting documents and all that, but our findings thus far, out of close to 40 cases, there was only one in which it was asserted that there was factual innocence of the defendant. Is that your understanding, or have you reached a different conclusion, or are you still working your way through it?
I'm still working my way through it, so I'm certainly not in a position to agree or disagree with that conclusion.
That's thus far, but
I mean, I can tell you that a lot of these cases are not actual innocence cases. There are a number that I've seen through my initial review where they are cases that have been fully adjudicated and reviewed. In some cases, they've already been through a second petition for post-conviction relief, so you may be on a third time. And so that's part of what I'm looking at. I'm looking at whether there was, in my opinion, right? I mean, I'm looking at this and reviewing the work and the decisions that somebody else made. But I'm looking at whether I think that there was a legitimate claim made and briefed for, say, you'll see some are Brady claims. Some have additional claims regarding non-unanimous jury verdicts. And I can tell you that if those cases were on direct review, then that defendant obtained relief through federal constitutional law. But post-conviction relief was foreclosed by the state Supreme Court and by the United States Supreme Court when it denied retroactivity of the Ramos case. So that would not be a legal basis for relief. And if there was a policy decision made by the district attorney that he didn't agree with that decision, then I'm going to make a note of that. So my position is the district attorney, the job is to enforce the law and not make the law. And so if the district attorney had a disagreement regarding legal policy, that's not a basis for relief. If the district attorney has a judgment call to make about the evidence and the strength of the evidence, I think that that is part of the discretion that's granted to the district attorney. But once you've been through multiple reviews by a judge, by multiple courts on those same claims, now you are undermining the decision not just of the earlier person who stood in your shoes as a district attorney, but of every judge and every court that has reviewed that case.
And the jury.
And the jury. I mean, the jury made a determination on guilt or innocence. The jury may not have made a decision on some of these evidentiary questions or constitutional objections that were made, and they may have come after that jury was long released.
And a number of these cases were guilty pleas.
Some of them might have been, yeah.
In any event, Senator Abraham has a question.
Thank you, Mr. Chairman. I'll try to keep it brief. I don't want to get too much in the weeds. I'm one of the non-lawyers up here. So you mentioned, I just wanted some clarification on what you said on the new law. You said the court has to determine, I guess, whether they get post-conviction relief, as I understood it. You said it used to be procedural, now it's jurisdictional. Is that correct?
So there's language in the statutes that refer to procedural objections.
And what does that mean, procedural?
It's not really defined in the law, and I think that's part of where there's some confusion. There are restrictions in the statutes on the basis for bringing a petition for post-conviction relief and the timeline for doing it. So, for example, you're supposed to bring it in a year. Now, we can have a whole separate discussion about some legislation regarding the timeliness of those petitions, because they frequently go on for they sit for a very long time, and that's because people file something called a shell petition, and then the shell petition sits around for years, sometimes before an actual substantive petition is filed and a decision is made by the court. But what usually happens in these cases is the district attorney asserts procedural objections and then doesn't have to do anything until a judge rules on those procedural objections.
The judge still has to rule, though.
The judge is supposed to rule on those. Now, if you waive them, there's nothing for the judge to rule on. And so waiving procedural objections is something that I focused on, particularly when it came to these subsequent petitions for post-conviction relief. Because remember, you've already gone through all of this when you're on a subsequent petition for post-conviction relief. So you made it clear in the law that the restrictions for a court to entertain a subsequent petition for post-conviction relief are jurisdictional. That means that it makes the judgment null if they grant it without.
That law takes effect when? When did that law take effect? The jurisdictional
August 1st.
August 1st. So
Right.
we're talking about that was not the law in the time frame you're referring to right now. Is that correct? The January through July.
It's
not as clear, I guess I should
Correct.
say. And that's where the procedural part was coming in January through July or whatever, and now we're on the jurisdictional side as of August 1st. Now, on the jurisdictional, that means that the court has to intervene or has to make a decision, right?
It places a burden on the court, on the judge, to ensure that those restrictions in the statute have been met. And when you say that there's a jurisdictional restriction on the court, it means the court doesn't have the power to entertain that petition unless those conditions are met. So it would go to the actual judgment and the ability of that judgment to have any legal effect in the event that the judge did not check those boxes.
Okay, so what we're really talking about here is the fuzziness of the procedural side that didn't really have court input, I guess, in a sense. Is that right?
I think that was part of it. I mean, the other part of it was if a district attorney was able to, went into court, as happened with a number of these cases, and conceded the merits or conceded the procedural, did not assert those procedural limits, there was no one to check that. There was nobody to come in and argue or defend the conviction. And so that's why I asked that the Attorney General receive service and the ability to intervene in those cases, because what we have is an adversarial system. It contemplates that someone will defend the conviction. Now, that's not to say that there could be cases where there's a legitimate, there are cases where there are legitimate claims. But remember, these are cases that have received a substantial amount of review by courts at this stage. And so it is important, I think, at that point, that we defend the conviction. And what we're seeing is 15 and 20 years later, sometimes 30 years later, someone's come in, a district attorney's come in and said, I'm going to waive procedural objections, I'm going to concede the merits, and we're just going to vacate the conviction and redo it all.
As a general rule, it's fair to say that the district attorney usually fights to defend the conviction his office obtained. As a general rule, it's adversarial. So, but what you're saying now is an inordinate number of cases the DA is saying we're on the side of the criminal defendant, and we're agreeing with what they're saying in their post-conviction relief motions or documents, and a judge signs an order, and then it's done without your being even notified, but for this new law that went into effect August 1st. Now they have
Correct.
to notify
I wouldn't have
you.
been noticed. I wouldn't have received notice of it before that.
Right, before August 1st.
The Department of Corrections receives notice because they have custody of the person. And so if they are in the custody of the state and state prison, then they get a notice. But the Attorney General didn't get a notice. And so now I have an express right to intervene and defend the conviction. I mean, I think that, the only caveat that I would say to your description is that every district attorney, I think, would also agree, and all of us would agree, that it is their job to do justice and that they should look at that petition and see whether there is a legitimate claim. But they should also do that in light of the prior history and the prior decisions that have been made by the courts to review those same claims. And whether, whether that district attorney is now stepping into the shoes of the governor and trying to basically concede an error that has been denied over and over and over again by the courts, that's where I would have a concern. But it is important for the district attorney to give us, to look at that petition and make the right decision.
Yeah, I'm good. That was a very good explanation. That's why I just want to clarify, zero in really what the heart of the matter is, and I think you've explained it very well. So thank you.
Thank you, Senator Abraham. Senator Miguez for a question.
Thank you, Mr. Chairman. Senator Abraham asked a number of the questions that I had, so I'm trying to clean up any gaps in the testimony. So, as it relates to, it seems like you touched on the point about the AG's involvement prior. There was no notice to you as a notice of corrections. Now you have it's required for this type of action to move forward. You have to be given notice and you have a right to intervene, correct? Is there any other powers that the new statute provides to the Attorney General in this process?
Service on the Attorney General and the right to intervene in a subsequent petition for post-conviction relief. That's it.
We talked about the procedural aspects, jurisdictional aspects. Would you say that the district attorney still maintains discretion after this new law is put in place and more of the burden is put on the judges? How do you manage? How would you say that is now?
I mean, I think, in any one of these cases, the initial burden is on the defendant who's been convicted to make the case that they are entitled to relief. So, when I look at these cases, when I'm conducting my review of the 40-odd cases that I'm looking at from January to July, I am looking to see what evidence was presented to the courts that wasn't already adjudicated previously by a court. And that's where I would say you probably fall more into a discretionary place where the district attorney has to really look at that and see, because that may be new evidence. But if it's already been adjudicated, then I'll have a column where I mark that that issue was decided by courts before it ever came up again in another subsequent petition for relief. So I'm not sure if that answers your question.
On the procedural side of things and the timelines, not to get too far down into the weeds, but your testimony was that the new legislation August 1st sort of cleaned up some of that fuzziness. Do you think there's any more improvements that can be done there to tighten up this process?
I do.
Any suggestions for the committee at this point in time?
I think I'd probably rather bring those to y'all in a comprehensive package, because there are a large number of statutes that walk through post-conviction relief. issues come up in those
Without putting you
proceedings
on-
that are kind of different, but you do see some common ones. And so I think there's some things that you could do. I'll make those recommendations.
If this committee and the
after I
legislature
review these
finds
cases.
that what may have had been happening prior to the August 1st legislation going into effect is an issue and a problem here in Louisiana, it seems like the August 1st changes may have not fully addressed those issues, and we can make further changes to improve the current law. That'd be your testimony here today.
Yeah, I do think there are some changes that we can make going forward. Yeah.
Now, tell me an idea. These you went through the whole scenarios of all the different relief that someone who's been convicted can go through. You went through all that in your outline, and we get into post-conviction relief. Tell me how often this happens, like in a jurisdiction. Is this something that happens? You see one like very seldom, or this happens in a multitude across the entire state?
Well, petitions for post-conviction relief are frequently filed.
Okay.
I mean, they start that process with the first round of PCR after a conviction.
How often are they
that's
granted?
the first
I guess you
round,
could
almost
say.
every time. So, unless they've pleaded and given up their right to appeal, then they're usually, as a matter of course, going to file for direct review, and then they're going to come back and file state post-conviction relief.
Subsequent
They don't
post-conviction
get that relief in most cases.
Okay, that was my
in most
question.
cases, it's denied, and in most cases, the district attorney comes in and immediately, as a matter of course, files procedural objections. And by filing procedural objections, the district attorney doesn't have to do anything else until the court rules on those procedural objections. And I mentioned these things called shell petitions. It can take years sometimes. I mean, limiting the amount of time that a shell petition can sit would probably be a good change to the law, because right now I don't think there is a time limit on that, and you can sit for 10 years and have a shell petition and then come back later and fill out that shell petition, and now all of a sudden you're dealing with claims that are 10 years old, with witnesses who may no longer be available. It is substantially more difficult to deal with a problem where relief is granted when the petition has not been addressed for that period of time.
But like in one of these jurisdictions, you'd say that happens where the relief is granted once a year, 10 times a year, 50 times a year in a
I
parish?
couldn't tell you that statute. I mean, that statistic, I really
seldom.
don't know. It is much different. I mean, the numbers in New Orleans are substantially different than the ones for other district attorneys around the state by a matter of hundreds.
Wow.
Madam
So-
Attorney General, you have a couple of people at the table, one of whom I spoke with as we were walking in the door, who could shed a little bit of light on that. If your colleagues could introduce themselves briefly. You don't have to leave the table.
Just sitting
We're
back.
going to have some more questions here.
Yes, thank you, Senator Morris. My name is Allison Rutson. I'm here on behalf of Hiller Moore from East Baton Rouge Parish. I'm in our appellate division. I've been there since 2008. I think I can answer some of your specifics, Senator. As far as the granting of PCR, that happens very rarely. We may have had maybe 1 to 3 grants in the last 5 years.
The last 5 years?
Yes.
Has
Now, this is
the
state
number?
post-conviction. The habeas numbers might be a little more, and if we're factoring capital cases in, that might factor, but.
So you've had 1 to 3 in the last 5 years?
From the court.
From the court?
Yes.
Where they've granted it, right?
Where they granted relief.
Is there anything that changed in the judicial systems, maybe since between May and August, which would in turn have more of these granted?
No, Your Honor, excuse me, I'm used to.
That's Senator Abraham. I'm Senator Miguez.
That's a typical mistake of a lawyer, so
All right,
just
first
excuse.
timer, can you tell? Nothing has changed. Our office is a little different. We have a lot of post-conviction applications. We probably get at least 100 filed per year. And
Has there been an increase because of the new law coming into play in August 1st? More requests? Anything that would have changed in the process to
we've
why
not seen
you'd
this.
have
We are not waiving. We've never waived procedural objections in EBR. So we've always asserted those when we can. In fact, when I train new attorneys, I always tell them to go look at the procedural stuff first. And the procedural is just different in that it's different from the merits. The merits actually get to the heart of the claim. A lot of times, those are easier to address because a lot of them are meritless. The procedure can sometimes, as we've seen today, you really do get into the weeds talking about procedure, but we always like to go with procedure first in EBR. So I can't speak to what other parishes are doing.
And tell me the main reason why you don't have more than 1 to 3 in the last 5 years. What's the reason for that? That are granted, mainly.
Our courts do like to afford the finality of conviction that comes with a conviction. They're supposed to be final. We get a lot of applications filed in conjunction with pleas. Sometimes pleas can be a little more problematic if a judge messes up or if an attorney hasn't advised. There are some changes in the law that do trickle down as far as a counsel's effectiveness and what is required of defense counsel at each different stage of the proceedings. It used to be in Louisiana that you weren't entitled to effective assistance of counsel at sentencing. Now that has changed in the last 5 years with the Harris case, so we do have to fight some of those cases. That is a battle with us that once you get a case out of the Louisiana Supreme Court, or definitely the feds, it applies to all of us. And so we have to look at that application going forward. Because, of course, defense attorneys are, they are good at what they do, and they try to expand the application of that case, whether we think it's very narrow or it should be applied narrowly. They like to widen it, and so that makes our decisions.
If you could speak on behalf of District Attorney Hillamore, would you say your main mission statement is, as being a district attorney, would you say public safety is number one?
Absolutely. Public safety and doing justice. And there have been cases. We absolutely believe in our juries, and we believe in our system and our processes and the checks and balances that are in place.
Public safety is number one, right?
Public safety, absolutely.
And how do you keep public safety here in Louisiana? Is by keeping criminals off the street. Would you agree?
Absolutely. Violent criminals, especially crimes of violence, have to be our focus.
We do have constitutional rights, and there's a process the Attorney General laid out in the event that the criminal justice system potentially got it wrong, right? Before we ever get to the conversation that we're here today for.
Absolutely.
And it's pretty extensive. Deals with a lot of judges, a lot of input to make sure that that decision was correct.
Any eyeballs are looking at that conviction from the time someone either pleads or a jury convicts that person. You have 3 judges at the appellate court. You have, in EBR, we have a non-elected commissioner. So we have a commissioner and a district court judge. Then you have 3 more judges at the appellate court. Then you have 7, 8 judges at the Louisiana Supreme Court. So by the time someone has been relegated to the post-conviction collateral review proceeding, you've had at least 10 to 12 eyeballs looking at that, in addition to the jury.
So when a violent criminal goes through this entire process, this whole process on the page, and exhausted this, there's a great chance that you guys got it right. The very, very seldom that you didn't get it right based on the numbers you gave me earlier, if you only are granted 1 to 3 every 5 years. Now, are those, you're a pretty big jurisdiction. Is those numbers similar across the state with other jurisdictions?
I can't speak to the other jurisdictions. I can only speak to EBR.
And you are one of the 5 largest?
5.
The largest would be what, Caddo, Lafayette,
Jefferson
EBR,
Parish, we are one of the
Jefferson, and
biggest.
Orleans,
Yes.
I would say, roughly.
Yes.
Okay, thank you so much. I appreciate it.
Thank you, Senator Miguez. Senator Duplessis for a question.
Thank you, Chairman. First, I want to thank you and the Senate President for allowing me to be a part of this hearing this morning, and thank you, A.G. Murrow, and your colleagues for being here. I just have a few questions, and I guess the first would just kind of be a little bit foundational in terms of how we got here today. So I would like to just kind of begin with what prompted this meeting, what led to us being here today. Yes.
What, do you want me to speak to that?
Yes, please.
I mean, I can tell you that I think there were questions that were being raised
By who?
In the public. I mean, I saw different people raising these issues.
Can you just
I've had
be
discussions
specific?
with other district attorneys. I mean, I
Okay.
started looking at some of these cases, but I mean, I think that questions have been raised for several years now, not just in the last few months. That's what prompted me to suggest some of those changes that we made in the law in February. But I had discussions 3 years ago with District Attorney Williams. And I want to say I've worked well with Jason Williams on a number of things. We have some differences of opinion about post-conviction relief. But this has started, I think more questions have been raised recently because there appeared to be more cases being pushed through in the last few months. Now, I can't tell you whether that's true or not. I really can't. I can tell you that I went and got the list of cases, and I am going through the list of cases to try and verify whether there were cases that were trying to be rammed through before I had a chance through the Attorney General's office to have an opportunity to intervene and challenge some of these,
Okay.
or at least have second eyes on them, somebody having some outside eyes on
So that information has been provided to you. The DA's office has been forthcoming with all the information you've requested?
They have given me a large couple of binders of information. I've shared that information with others, and they have indicated they'll give me any other information that I ask for.
Okay, so we've been having a lot of conversation and discussions around post-conviction, which I think all of us would agree, whether you're an attorney or not, that post-conviction is a pretty specialized area of the law. It's not something you learn in first-year law school, second-year law school, or even third-year law school. And most attorneys are not even familiar with the area of post-conviction law. And you have some attorneys next to you that do this work, but it's a specialized area of the law, is it not?
It is, and they do
Right.
teach it in law school, but you have to elect into
Yeah,
it. And
but
I
it's not
took it and
something that
didn't
you're
understand
guaranteed
it.
to know.
So you can, I think everybody who does this kind of work would agree that it is specialized work, and that most lawyers really don't do this kind of work.
So we had a lot of debate on Act 10 that was passed in the special legislative session on crime that you mentioned earlier, but we had it in Jude B. Why are we in Jude C today?
Couldn't.
Because I called the meeting.
Okay, all right. And you, Mr. Chairman, you had a bill, I remember in Jude B too, that also dealt with DAs in particular. That was also in Jude B. So I'm just again curious as to why we're in Jude C today, because we've always had this
It's
debate
typical,
around
yeah.
post-conviction or dealing with prosecutors in Jude B. So I'm just curious, just a question, but you as the chairman have that discretion.
A, B, and C don't have defined.
Well, I'm just looking at custom.
Historically, yes, we
I'm
do
just looking
handle
at
most of the
custom.
criminal matters, but.
Because we had extensive debate around Act 10 that was passed during the crime session and some of the concerns there. And I raised questions and concerns, particularly as it relates to the issue of prosecutorial discretion. You had members from your staff who were there who sat at the table and asked certain questions. I want to go to the most recent Supreme Court ruling on this that you actually just cited. I believe it's the Lee case that talked about retroactivity or the lack thereof as it relates to non-unanimous juries, the non-unanimous jury decisions. And I want to read a portion of the holding that clearly states, and I'm just asking if you disagree with any of this, that if a defendant seeks post-conviction relief, a district attorney is now required to oppose the application. For example, if a defendant claims his conviction was obtained in violation of the Constitution because he was denied effective assistance of counsel, or because the state withheld evidence under Brady, in violation of Brady, the DA may choose not to raise procedural objections even when they apply. Furthermore, and this is the most important part, the district attorney has absolute discretion under the Louisiana Constitution, Article 5, Section 26, and the Louisiana Code of Criminal Procedure to not oppose or even join an application for post-conviction relief that raises a cognizable claim for relief. The broad authority is necessary because a prosecutor's responsibility is as a minister of justice, not simply that of an advocate. So going to the issue of prosecutorial discretion and the discretion that was exercised by D.A. Williams or any DA across the state, because it's my understanding this isn't the first time this has been done, maybe at the volume, but did that case at all speak to the amount of negotiations that could be entered into or agreements that could be entered into by a DA, then signed off by a judge? Did it speak to any issue of the amount? Is there a limit?
No, it didn't, but let me say this. I believe you are quoting from Justice Weimer's statements in that case, and I don't entirely agree with the blanket statements that were made in that case. Post-conviction relief is a creature of state law. You are not even legally, constitutionally required to provide it. So it is entirely a process that has been created by the state legislature to offer another avenue of relief.
Does
So
state law require the DA to oppose an application for post-conviction relief?
it does now on subsequent petitions for post-conviction relief, and I believe that is entirely within the discretion of the legislature to create.
So was anything done by DA Williams that was in violation of the law then or now?
I can't tell you that yet because I'm looking at every case individually. And what I am looking at, to be very clear, is whether those cases involved decisions by the district attorney that really amounted to a disagreement on criminal justice policy.
It's a policy decision.
A policy
It's a
decision,
policy
because
decision.
in a lot of these cases, as you point out, they have gone through subsequent post-conviction relief. They've gone through the first round. They've gone through the federal round. In some cases, they've come back and gone through another second round, and they're on their third round. So, you know, you are, in some of these cases, substituting your judgment for that of not only the jury, but the judge who gave the sentence, the legislature who established what those sentences should be, or the range of sentencing for certain crimes, and then subsequent courts that have reviewed those sentences and determined that there is no legal error and that it was appropriate. So that's what I'm looking for, and I think that I'll come back and tell you what I find.
Sure.
But I mean, I've already found in
but
some
ultimately,
cases
since we already acknowledge that no matter what, it will boil down to a difference in viewpoint from a policy standpoint. So when you say what your findings are,
but it's
the
not
question,
it is not the job of the district attorney to disagree with the legislature, the judge, and the jury on the criminal justice policy.
But any of those decisions still have to be signed off by a judge, do they not? Can the DA just make the decision on his or her own without the judge signing off?
In front of a judge.
So the judge still has to sign off on it.
But if there's no one objecting, and if they have completely conceded on the merits, there's no one. I mean, what is a judge to do when the district attorney is not actually adjudicating?
But that's still within the law.
I didn't say it wasn't within the law. I said there's no adversarial in the system at that point, and so a judge is not going to advocate in the system.
Okay.
And that's one of the reasons why I asked for the change on subsequent
Right.
petitions for post-conviction relief, because if it is a matter of policy, then I believe somebody ought to be in that system defending the conviction.
So you got the change that you sought in the law during the crime session. So why are we here today?
Because we're looking at, I guess, what's happened in a number of these cases.
I think that will explain itself as we go through, because I called this.
Okay,
In response.
So we got the change in the law. So I'll ask you, Mr. Chairman, we got the change in the law. So why are we here today?
To determine whether or not what has happened thus far deserves a policy adjustment in the future. I think Attorney General Merle has already said that she thinks that next year we probably should change the law a bit more. And so,
But the law just took effect August 1st.
Right, but she's suggesting there might be other changes, and as we go through this process, and by the way, this is not going to be the first hearing on this. We're going to have more. We're at the preliminary fact-finding stage, and we'll be going through some of the cases that cause a lot of concern by members of the public. And we can get into those weeds in a bit.
I'd like to go there just a little bit, talking about members of the public, because we have locally elected DAs. We have DAs from all across this state. We have an elected AG. And the people we elect reflect the values and reflect the policies that the people of that area want to see in the people that they elect. So this question of the democratic process and who we elect or don't elect based on the values of that local electorate should be reflected in the people that they elect. Do you not agree with that?
I mean, I think you're making very general statements. I don't think that we
It's a
elect
clear
people to
statement.
nullify the law.
Okay, let me ask you this question. This is straight from the core values of the LDA, the Louisiana District Attorneys Association. I just want to ask how you feel about it. Louisiana District Attorneys Association clearly states that we believe that the Louisiana Constitution requires and Louisiana citizens favor locally elected independent prosecutors. We believe that prosecutor discretion must be protected from interference through manipulative funding or legislative restrictions. Finally, we believe that prosecutors are the best and most trustworthy resource for legislative improvements to the criminal justice system. Do you not believe that this hearing that we're having today and this effort is in some way an overreach to DA discretion or in some violation of the spirit of the core values of the District Attorneys Association for independence for DAs?
Hey, look, I support the DAs. I work closely with the DAs. I assist the DAs in prosecuting cases, and I take their recusals. And I am, in effect, a DA in that sense. I stand in their shoes when I take cases that they can't handle, or for whatever reason, not that they can't handle them, that they were recused from. I think they do a great job. I think we have great DAs. They are elected, and I respect that part of our process.
So every time
there's
there's a
nothing wrong with
difference,
the legislative oversight hearing.
so every time there's a difference in a policy decision that's made by a local DA, we're going to have a Senate hearing, change the law based on someone who's been duly elected. That's why we have elections, do we not? That's why New Orleans. That's why the city of New Orleans went in a different
We're getting
direction.
kind of beyond the scope, and we're talking in platitudes now.
Yeah.
No, I'm not talking in platitudes. I'm just asking the question.
I understand your question, but we can't take up the whole hearing, you guys bantering back and forth over the 50,000 level. We need to move forward. I would ask Senator Duplessis to just ask some specific questions about the facts before us or the facts we want to get out today so we can get to we have witnesses at the table who hadn't even had a chance to speak yet. And I've got members who need to leave. They can't stay into the afternoon, so I do want to try to get through this meeting where everybody has a chance.
I respect that, Mr. Chairman, and again, I appreciate you for letting me be a part of this hearing today. But I think these questions are important. And I want to be clear, I'm not here to defend the district attorney. D.A. Williams is fully capable of defending himself, and I'm sure he's going to have the opportunity to speak on behalf of his office and his policy decisions. I'm here to defend the process and what's going on here today. And on behalf of the people of New Orleans, I believe that the people of New Orleans, with a nearly 60% vote, made a decision in 2020 to go in a certain direction based on certain policy promises that were made. So these are not platitudes. We're talking about policy decisions.
And respectfully,
that the city
Senator
of New
Duplessis,
Orleans
I don't think
made.
the victims of some of these crimes would agree with you. I mean, we have criminal justice system. I'm here too to talk about process. And when you have settled convictions, our process contemplates finality in that system.
But
and what we are
is there
talking
any
about
violation of the law that took place, AG?
But some of these aren't violations of the law. I mean, that's my whole point. That's what I'm looking at. Was there an actual violation of the law? If that's been adjudicated already by a court multiple times, and that court has found that there is no violation of the law, now you are talking about one person who has come in and substituted her judgment or his judgment for that of all of these people in the system, including the jury. And that's what we need to take a look at. I think that...
Okay. Are there any instances of these negotiations or these agreements that took place prior to the Williams administration in Orleans Parish?
I'm sure that every district attorney has these cases that come up.
So that's a yes.
Yes, but
Right.
I don't think anybody has several hundred of them.
Right, but again, going back to the law, going back to the Supreme Court ruling, there was never any restriction that was specifically put on the DA discretion in terms of volume.
I don't think that's a fair description of the whole system. The system contemplates an adversarial system where the district attorney is the prosecutor.
So it's
not
okay
the
if they do
defense
less
attorney.
than 10, but it's not okay if they do more than 25? Like, what's the range to where it starts to get to a point of
Every
concern
case
for you?
has to be looked at on its own merits, but I mean, I think that you'll see from the flat numbers that the system is set up to favor finality of convictions and not to have revisiting convictions 15 and 20 years later because of a difference of opinion in criminal policy rather than actual legal grounds for relief.
Okay. I'll bring my questions to a close, at least for your presentation, and it'll kind of end it going back to a point that Senator Miguez was referring to, and that's on the issue of public safety. Has District Attorney Williams been a willing partner in working with you and the governor to deal with public safety in the city of New Orleans?
He's been very cooperative with me, I'll say that. Yes.
Okay. Have we seen a significant reduction in crime in the city of New Orleans?
We have, since we brought more troops into New Orleans and we increased prosecutions
Okay.
there. I think there's been a substantial decrease.
Okay. Thank you.
Thank you, Senator Plessis. I see the board is clear. There's another gentleman at the table. I don't know if you want to speak. If you do, please introduce yourself and let us know.
Good morning, Senator Morris. I don't have anything to say unless there's specific questions for me, but my name is Taylor Gray, and I'm the Chief of Criminal Appeals for the Attorney General's Office.
Very good. Just as an aside, I've got a criminal defense lawyer in my family, I think I mentioned. I have an assistant DA in my family. I'm a lawyer, obviously not a criminal lawyer. And as an elected official for the last 13 years, I get letters from inmates from time to time. Everybody is innocent if you ask them. And everybody that gets convicted says their lawyer didn't do a good enough job. Is that a fair statement?
That is an absolutely fair statement.
And so it's incumbent upon you as a district assistant district attorney and the other district attorneys in the room to pour through those assertions and determine whether there are any merits. And in large part, what I'm hearing is that most convictions are valid, and you don't have a problem going forward.
The large part, yes, sir. Mr. Moore asked me to pull our stats in East Baton Rouge Parish, and since 2005, I'm aware of 4 plea deals that we have made post-conviction, and in each one of those cases, there was an active post-conviction application filed, and there was an issue, either a discovery issue, or an evidentiary issue or intervening case law that impacted our ability to go forward. So there are, and they're all sad situations.
And with respect to prosecutorial discretion, they have that because our Constitution and our laws give it to them. It's not inherent. That can be altered by changing the Constitution or by the laws, correct? Madam Secretary.
Senator Morris, I would just say that prosecutorial discretion doesn't mean absolute discretion to rewrite the law. I mean, the law is already written. The district attorney is applying the law, enforcing the law, and then defending the conviction. So, and it does change. Once you're convicted, before you're convicted, the presumption of innocence attaches. Once you're convicted, then there is a presumption that those proceedings were handled properly, and so it changes. But again, I mean, I think that it's built as a system that is built around our job as prosecutors to enforce the law.
And as a legislature, if we believe that public safety is endangered because of the activities, and I'm not saying there it is or isn't, but we have concerns, it's fully within the right of the legislature to address that situation by a policy response. Would you agree?
I mean, I agree, and I mean in the context of post-conviction relief, I'll take you back to what I started with, and that is that it is entirely a creature of this legislature.
We could repeal post-conviction relief.
You could,
Totally.
and I'm not here to tell you to do that.
Well, I'm not suggesting we should, but we
created.
But we could. We create it. We could take it away. We can't take away federal habeas corpus writs, and I wouldn't want to. But there's always going to be a means to protect people who are factually innocent. But thank you for your testimony. The board was clear. Senator Cloud now has a question.
Thank you, Mr. Chair. For somebody who is not a criminal defense attorney, not a lawyer, I don't do what you all do. I am a citizen, and I am a lawmaker. Walking us through this chart, and I wasn't going to speak about this, but walking us through this chart and the realization of how many opportunities for review, how many levels and how many sets of eyes that are looking at the merits of an appeal. And knowing now learning through this that multiple opportunities with multiple sets of eyes at multiple levels, and still in all, at the end of the day, our state law does provide for one person to override all of this review, all of these sets of eyes, all of the fact-finding over all of the years, that one person can do that unilaterally with their own discretion, and to think that we shouldn't question it as lawmakers, as a society, if we're all crying out for changes in our criminal climate
I'm going to let these people go.
in Louisiana, and yet we're not going to look at this. I think that this is incredibly healthy, and I think that we should be here today, and we should have more of these in the future, because it provides a level of accountability. If there are loopholes and errors in our law, in our system, we need to have that discussion. We can't make all of these changes, spend all of this time on criminal justice reforms that we have been over the last several months, and then have this one opportunity to nullify all of the work that we've done for a safer Louisiana. So I think this is incredibly healthy, and I really appreciate the opportunity to learn about all of this.
Thank you, Senator Cloud. And I would just add one thing before I step away from the table, just kind of to your point, Senator Duplessis, about the discretion of the prosecutor. There's another Supreme Court case that I think is relevant to this discussion, and it relates to a statute that was recently declared unconstitutional by the Louisiana Supreme Court, because it did place greater discretion in the hands of a judge, a defense attorney, and the district attorney by consent to grant relief. And the Supreme Court said that was an unconstitutional violation of the governor's clemency powers. So, on the far side of that chart is the governor's power, which is also in the Constitution, and that's at the always inherent in the process, where the governor has the ability to convert, grant clemency, or reduce the sentence.
Okay, I am going to recognize Senator Duplessis, but if we don't move on, I am going to have to impose a time limit on questions.
Thank you, Chairman. Look, we're on a fact-finding mission, right? That's what we're doing, right? I just want to make sure that what we're saying is factual. I am just as concerned about public safety as anybody else in this state, so I want to be clear about that. For the record, Madam AG, crime was going down before Troop NOLA came to New Orleans. I just want to state that for the record, all right? And it's going to continue to go down, but the statement was made that the DA is unilaterally undoing these sentences, and that is just factually not true. You didn't say that, but we just agreed that this still requires the approval of a judge, and I just want to state that for the record. Thank you, Mr. Chairman.
Thank you.
Thank you.
Okay. Thank y'all for appearing. So we've got some former prosecutors and State Representative Debbie Villio happily is with us today. I don't know if there's room, and Chris Walters, attorney with the administration, is also here and has been analyzing these cases. So
I can move for him. All right.
with that, I'm going to, I know that you all have some information you'd like to share with the committee, and some slides and things of that nature that may get into a little bit more detail about why we're actually here today. So I will turn it over to you three and let you handle it as you would, but you're here at my request after having analyzed a lot of the information that has been provided that you all were able to extract from the court records. Although that was an issue, I understand you can explain that, as well as some of the information that District Attorney Williams has provided to the Attorney General. So with that, I'll let you guys start.
Sure. Again, and introduce myself. My name is Laura Canizero Rodrigue. I am a former prosecutor. I now represent law enforcement. I served as a prosecutor for about 13 years, starting in Jefferson Parish, and then the remaining about over 10 years in Orleans Parish, primarily, actually exclusively in the Trials Division. Blake Arcuri.
I'm a former prosecutor, also represent law enforcement agencies sued in civil litigation.
Debbie Villiers, State Representative and Chairman of the Criminal Justice Committee for the House.
And a former prosecutor as well.
And a former prosecutor.
So we were tasked with, just as the AG mentioned, it certainly became an issue that was brought on the radar of the public with this new legislation addressing post-conviction relief. The legislation basically was brought in an effort to curb any sort of discrepancies in post-conviction relief. It was thought that there was a rush by the Orleans Parish District Attorney's Office to essentially undo as many convictions as possible prior to that August 1st deadline when the legislation would take effect, which would require the PCR to be served on PCR, and that's post-conviction relief, which would require the PCR to be served on the Attorney General. We started looking at certain cases. The reason we were notified of this were several lawyers were bringing information to our attention after seeing things in court or hearing about cases or pleadings, and we would look at Docket Master. So as the chairman said, our review thus far, we have obtained hundreds of pages of records from the Orleans Parish Clerk's Office. We got those ourselves and went through what pleadings were available to us. For purposes of the slides that you're going to see, we focus primarily on 2024. We know, or records from DOC indicate, that there are somewhere between 300 and 350 persons who were resentenced by the DA since he took office in Orleans Parish. We obviously did not have the time to go through 350 cases to determine what happened in each of those. We focused on the year 2024 and learned from the DOC that there were 42 people in Orleans Parish who were resentenced in this year. We noticed in the numbers from the DOC that did increase, and I'm citing, I believe, this is off of memory, but I believe there was one resentencing in January, one or two in February, maybe one or two in March, and then we start to see it increase dramatically leading up until the week before the legislation took place. We would see 10 or 12 in the weeks leading up until the August 1st deadline. So it did raise concern that there was a rush to get these cases resentenced before the August 1st deadline. In the review, in what we could obtain in a review from the clerk's office from the 42 cases, we've put together a sort of the best sort of sampling we can of what was going on with the cases that we reviewed. Many of the cases had a response from the state. In other words, what the AG had said before, the defendant initially files the PCR application. He or she says, I believe I'm entitled to post-conviction relief, and this is why. Typically, the state will then respond and defend the conviction. In many of these cases, in the 42, or actually we didn't get to 42, I would say we saw somewhere between 35 and 40, the state was joining in the defense's request to get post-conviction relief. I want to note that the chairman said that there was only one case where there was an allegation of actual innocence. There was only one case where the words actual innocence were used in the pleadings that we reviewed. But that person was also required to plead guilty to the crime of obstruction of justice, and you'll see that. So in none of the cases we reviewed was a person deemed to be actually innocent by the district attorney's office. In every single case, the defendant was required to plead guilty and admit guilt in his participation in the crime. So I'm going to move now to the slides where there's a few slides, and I'm happy to take questions, whatever the chairman prefers, but these are the general concepts.
Why don't we go through some of these, and then we'll take questions.
Sure.
Rather than interrupt your presentation, if we can help it.
So these are some of the general concepts that we addressed in the slides, and retroactively applying Ramos and Cage. Those are two landmark Supreme Court decision cases out of the Louisiana Supreme Court. Ramos is the one most of you are probably familiar with. Ramos said that Louisiana will now join the rest of the country in requiring unanimous jury verdicts. So you cannot no longer have 11-1 or 10-2 verdicts for a conviction. Ramos required a unanimous jury in Louisiana. After the Ramos decision came out, the Louisiana Supreme Court said, in no uncertain terms, Ramos is not to be applied retroactively. That means any convictions that were final prior to the decision of Ramos would not get relief for a non-unanimous jury. And that this is a category that will go to the point made by Senator Duplessis earlier on the Ramos and the Cage decision. Cage, a similar case out of the Louisiana Supreme Court that talks about a jury instruction that courts were giving to the jury before they went to deliberate. The judge was instructing them on the definition of reasonable doubt. That case comes out and the court says you need to change that jury instruction. This will be the new way you give that instruction from here on out. But under Cage as well, the Louisiana Supreme Court said this decision is not to be applied retroactively. If a conviction is final, you do not disturb any of those prior convictions. This is to go from here forward. So that's what we're going to see on Ramos and Cage.
I would add to that the United States Supreme Court did weigh in Edwards versus Vinoy and said that that Ramos, actually looking at our case and our law, and said that there's no requirement under federal law, the federal Constitution, which ours is very similar to. There's no requirement to apply that retroactively.
Correct, and I appreciate that. That's the federal side as well. So the next categories are going to be more self-explanatory when you see the slides. A motion to dismiss a multiple bill. What we mean by a multiple bill is if a person is convicted of a crime and they have prior convictions, the state can then what we call multiple bill them. It means enhance their sentence or their penalty. It will enhance the range that the judge can sentence the defender to based on their prior convictions. So they could be a double bill, meaning they have one prior conviction. They could be a triple bill, meaning they have two prior convictions. They could be a quad bill, that's the highest, meaning they're facing 20 to life. They have 3 or more prior convictions. So we see many motions to dismiss a multiple bill, and we'll talk about that. There are motions to correct what they call an illegal sentence, and we'll see what that looks like in the actual pleadings filed by the state. We have public safety concerns. We'll see several of the people who were released and then went off to immediately reoffend, committing murder, picking up gun charges, going federal. You'll see some of those. We have no claims, as we've discussed, of actual innocence. You're going to see language that we have pulled, sample language from the state's own pleadings, admitting that the guilt of the defendant is clear, but that maybe his role was less, more of an accomplice. In Louisiana, we might call that a principal, right? And we'll talk a little bit about that. These are their own pleadings that they have filed. We see a judge in criminal court raising concerns about a PCR hearing, and we're going to look at those particular facts. Very, very interesting facts about testimony during a PCR hearing. And the next ones will be sort of more self-explanatory, but you'll see that there's a result of this that affects the state financially too. Civil litigation follows when somebody's released, and we're going to see those numbers comparing them to other major parishes in the state. Okay, so here is the Ramos and Cage application. So these were 10 cases. Those are cited at the top. And again, this is just based on the limited information we have, but the basis for the DA's office undoing these 10 cases, and remember, we've reviewed around 35 to 40, so 10 of those are reverse applications of Ramos and Cage, meaning they went back and applied a law that the Supreme Court and the United States Supreme Court said they could not retroactively apply. Now, this language comes directly from a pleading filed by the state. This is what they put in their pleadings. The Orleans District Attorney's Office is committed, regardless of strict legal entitlement, to to confronting past harms and excesses, including convictions that may have been infected by constitutional errors which were not remedied by retroactive application of governing law. The state seeks to build faith in the fair administration, and it goes on. Same paragraph in every single one of those that they file for retroactivity, meaning this is an admission by the state that they do not have legal entitlement to go back and retroactively apply Ramos or Cage. Their words, not the defendant, the state. So admitting they're aware of the law. A special note at the bottom, and we cite a state case. This is a state from the Orleans Parish DA's office, State versus Tyrant's Chancellor. We found a pleading there. Okay, let me make this distinction too. This is the Civil Rights Division of his office that we are primarily talking about, involved in all of these cases where PCR is, okay? So that's a special division created by the district attorney within his office. They are handling all of the post-conviction relief. We see other lawyers in the trials and appellate division in his own office, and of course, as well as other lawyers in every other state, in every other parish in the state, stayed cases instead of retroactively applying Ramos. They knew they were not supposed to be retroactively applying them. That's out of his own office in other divisions. So only the Civil Rights Division is coming in and retroactively applying Ramos. Every other case in his office, the prosecutors are staying before they make any decision to see what the Supreme Court rules. So that's an interesting factor to consider in determining the application of the law here. Okay. The next few slides are going to be a few examples of a few cases we were able to pull. State versus Reynolds Scott. Scott was convicted of aggravated rape in 1989 by a non-unanimous jury. The date, 1989. That should trigger some information that you just learned from the AG in terms of timeliness here. The victim was the ex-girlfriend of Scott. Scott accused her of cheating, threw her onto the pavement, knocking out all of her front teeth. He wrapped his belt around her neck and raped her. The victim displayed her missing front teeth to the jury at her testimony in trial. On April 30th of 2024, decades after his conviction was final, Scott filed for post-conviction relief based on the Ramos case. On May 17th of 2024, months before the new legislation takes effect, the state releases him based solely, and I have, that's the next defendants, but that's Scott, based on the retroactive application of Ramos. There's no indication in this case whether there was any victim contact. Okay, so this is just one example of the retroactive application of Ramos. Clearly nowhere near the deadline here. We have a conviction coming out in 1989. This is a Lawson. State versus Joseph Lawson. Lawson's convicted of first-degree murder, November 11th, 1979. He shot and killed his ex-girlfriend and her friend, who just happened to be sitting beside her at the time that she was approached by her ex-boyfriend. He kills both of them, point blank, shoots, if I recall correctly, one of them in the chest, and then just shoots the friend before he walks away. Decades after this conviction was final, he files for post-conviction relief. I don't have the date. There was no docket master available. Again, we're talking about a 1979 case here. On July 31st, one day before the new legislation is set to take effect, the state releases him based on retroactive application of the Cages case. The state notes in its own pleading here that this release was against the wishes of the victim. This is their quote. The state has contacted the victim's two surviving siblings. One has expressed that she leaves the matter to the judicial system. The other indicates he does not support a charge or sentence reduction. So that's noted. We have victims here actively asking for this person not to be released who murdered their sister. And we have a retroactive application of Cage. In his own pleading, he admits there is no legal entitlement here. State versus Lester Duplessis. Duplessis is convicted of first-degree murder, sentenced to life on May 15th of 1997. He tied up two victims, covered their mouth and nose with duct tape, and then executed him. In fact, in the coroner's report, they say the only way they knew that they hadn't been asphyxiated first was because there would have been less blood, or in other words, they have to actually do an evaluation to see whether they actually suffocated from all the duct tape first or from the gunshot. All appeals and post-conviction were final March the 30th of 2009. On June 6th of 2024, the defendant files for post-conviction relief. Weeks later, on July 26th of 2024, days before the new legislation takes effect, the state releases Duplessis against the wishes of the victim. No legal basis here. We went through that process, and obviously I can't put everything on one slide here, but you'll see the pleadings. And the victims here note that they are opposed to relief in this case. So again, we have victims speaking out against the relief. It's important that you note that a lot of these post-convictions, and I assume this will come up in a subsequent hearing, the difference in the date between the filing of the post-conviction and the granting of the relief is days sometimes, weeks other times. As you heard, and I believe it was from the lady from East Baton Rouge Parish, most of the time you will see lengthy litigation from the DA's office, months, if not years, of post-conviction litigation. It is not a decision made in days or weeks. It takes a lot of time and effort and an investigation to determine whether post-conviction relief should be granted. That's why we see in East Baton Rouge 5 in the course of 5 years. So they're averaging maybe 1 a year. It is a lengthy process, something we certainly don't expect to see happening in weeks. State versus Matthew Miller. Miller was convicted of second-degree murder on October the 10th of 1991. He stabbed his wife to death after having an argument with her. All post-conviction relief was final November the 3rd of 1998. January 17th of 2024, he files for post-conviction relief. Again, we're at that July 24th, that week right before the August the 1st deadline. Against the wishes of the victim, he's released. There is no legal basis cited. They cite that the family this is in the state's own pleading, the 2 surviving sisters have expressed opposition to a reduction in the sentence on their own behalf and on behalf of their father, who is still alive but elderly. So just another example. Here is one of the final examples, and this is obviously we just put a few, but there are many more. Alan Johnson's convicted of first-degree murder September the 28th of 1981. He got into an argument with his supervisor at work and beat him unconscious. Once he was knocked out, Johnson mutilated him with a machete and told a coworker on his way out that he was next. This is the state's own pleading describing the gruesome nature of these facts. There is no doubt that the crime for which Mr. Johnson was convicted was brutal and deserving of condemnation, the most serious offense in the code. They go on to admit he was guilty. The defendant unjustly and violently attacked and killed Mr. Tamke, the victim. Decades after the conviction is final, he files for post-convictional relief. We don't have the exact date because we don't have docket master here. July 19th, again, right before the August the 1st date, the state releases him against the wishes of the victim. In this case, the victims actually had to hire an attorney to sort of navigate this process. So we have an admission here of the brutal nature of the facts. There is no indication that there's any innocence here. They admit that the defendant unjustly and violently attacked and killed the victim. Those are some of our general examples. I want you to understand what we're talking about when you hear a motion to correct an illegal sentence, because it was really important to understand the nature of the pleadings, what they're alleging, and whether there is, I guess, the truthfulness of what's being asserted here. If you look at this particular case, they say that this is a motion to correct an illegal sentence. This is the State versus Terrence Burton. This case has gotten media attention recently. On May the 21st of 2014, Terrence Burton, and the DA represented the co-defendant in this case. His former law partner represents Mr. Burton in post-conviction. In the middle of trial, Burton says, "I've had enough. I can't take it anymore. I'm taking a plea." I guess he sees what's about to happen here. He believes the jury is likely to convict him. He takes a plea to 40 years. That's the sentence he agreed to in exchange for not having a jury render a guilty verdict with a mandatory life sentence. He receives a 40-year sentence on all 4 counts to run concurrent, okay? There was a count of manslaughter and 3 counts of attempted first-degree murder. 4 counts total is what he pled to.
He shot 4 people, right?
He shot 4 different people. 1 died, 3 survived. The 3 are our attempts. The dead person is the manslaughter. On May the 10th of 2024, the DA released Burton, claiming that the judge failed to state that he was eligible for parole on count 1, the manslaughter count only. That would be the only count he was eligible for parole on. This claim was actually raised, and we see this in the docket master. He made this same argument to the Fourth Circuit, and it was rejected. His conviction was made final in 2019. This DA's office comes in. Aside from the fact that this had already been decided by a higher court, if the DA wanted to correct the portion of the sentence that he believed was illegal, it was only necessary to put on the record that he was eligible for parole as to count 1, the manslaughter. Counts 2, 3, and 4 should have all remained the same. And there was no need to do anything with the 40-year sentence. That was the sentence that the defendant agreed upon in lieu of finishing the trial. And the state never had to agree to give him any sentence at all. The state never had to agree to give him a plea in trial. He agreed to that in exchange for not getting a life sentence. Instead of correcting this quote-unquote illegal sentence by adding the word eligible for parole on count 1, he vacates the sentence on all 4 counts, vacates the 40-year sentence, and reimposes a sentence of 14 years, and Burton is immediately released. So that's what you have to understand when you see something that says motion to correct an illegal sentence. It requires determining what was illegal about the sentence and if what is purported to have been illegal was actually what was corrected. And we see this one example absolutely not true here. We have a motion to dismiss a multiple bill in several cases. I think there were at least 3 or 4. I can't remember the exact number. The pleading where they ask to dismiss the multiple bill, meaning take off that enhanced sentence, which can afford him his immediate release, is basically the entire pleading is based on the argument that the multiple bill is a racist document. That's what is cited in the state's pleading. We do not get any citations to where this data is coming from. Here are 2 pleadings, both from the state, citing separate statistics. Okay? One of them says at the start of 2021, there were over 900 people in custody of the DOC from New Orleans who were serving at least one sentence enhanced by the habitual offender law, essentially saying 900 people in the DOC under a multiple bill. Another pleading, same one, same office, says at the start of 2021, at least 718 people from the Orleans Parish or in the DOC on a habitual offender law. So we don't have any stats to show where they're getting this data. We're not able to verify any of the data. We have no idea what it's based on. And these are the pleadings that are being filed to undo a multiple bill. And based on the limited information that we have, this is all we have to look at as their basis for undoing these and releasing people on a multiple bill. No claim of innocence of any of them. Not even a claim of less culpability, prosecutorial misconduct, none of that. None of that on the multiple bill ones.
So just to clarify, there's nothing wrong under the law with charging someone under the habitual offender statute.
No, of course. That's what the legislature has determined is applicable to a prosecutor when they're evaluating a case. And I would think that the community would expect that. In other words, a first offender should not be treated the same as a fourth offender, right? There should be opportunities afforded to somebody on their first arrest or first conviction. But if a person got that opportunity on the first time, got that opportunity on the second time, because I can tell you they're usually getting probation on the second time, they might get it on the third time too. By the fourth time, there are some laws in place to say now we have some options here because every opportunity afforded on time 1 wasn't taken advantage of, not time 2. And the problem is we see an escalation in crime most times, and we'll see some examples of that too. The point being, the habitual offender is illegal. The habitual offender law is a legal tool used by prosecutors to ensure that first offenders are not treated the same as second, third, fourth, fifth, sixth, and seventh offenders. So there is no legal basis to undo a multiple bill. And we don't even really have any factual statistics here to back up the numbers that they're citing in the pleadings. Okay, this slide is just a sampling of some of the language where they release somebody, but it's just examples of the fact that none of these are alleged to have been innocent people, wrongly convicted, the wrongs of the past, any of those things. Here we have Waters. Waters could have more credibly, this was a murder. Waters could have more credibly cast Max Steele as the primary perpetrator. They're saying he could have blamed somebody else for this. The experienced hitman who planned and contemplated the crime. While Waters could not have undone the physical evidence, he certainly could have mitigated his own level of responsibility and elevated Steele's role. So basically make somebody else look more guilty. At the end, it says, Waters could have presented himself as someone involved in the crime and in receipt of stolen goods, but perhaps as a non-shooter or a less culpable accomplice or accessory after the fact. Okay? The state's making an important notation here. They said Waters could not have undone the physical evidence. In this case, Waters is found with a shell casing in his pocket, a ski mask on him, an injury to his head that he was unable to explain even when he took the stand in his own trial, and keys in his pocket to the hotel room where the evidence was all located. So the state's basically saying, look, you really couldn't have undone the evidence that was here, but maybe you could have blamed the other guy, made him look more guilty, made yourself look a little less guilty, and you could have just been an accomplice. The problem is accomplice in Louisiana is defined as a principal. A principal is anybody present or absent who is involved in the commission of a crime, and they are just as guilty as the person who commits the crime. An example would be an armed robbery. If you're the one holding the gun or you're the one getting the cash from the register next to him, you're both guilty of armed robbery. You're a principal to the crime, and the penalty is the same. So this argument makes really no sense in terms of the justification for a release here. On the slide under that, to be clear, the state does not concede there is any likelihood Mr. Thomas would have been acquitted, but a measured response to petitioner's claim must concede a reasonable likelihood that a fully informed jury could have come back with a manslaughter verdict. So they're saying here, we agree he's guilty, but he could have possibly gotten manslaughter maybe. Maybe he could have tweaked some facts a little bit and gotten the jury to come back manslaughter. Not a legal basis to release somebody. The possibility, and remember, the jury is instructed on manslaughter when they render a verdict for murder. Again, just a sampling of the fact that none of these are a legal basis and nobody is claiming evils of the past in any of these pleadings. The one at the top is very interesting, and they make an Eighth Amendment claim that the newly discovered evidence is his diagnosis, a cancer diagnosis, and that's the basis of release. So the sentence as applied violates the Eighth Amendment. The state concedes that it is based on new evidence, his diagnosis. So imagine the floodgate that would open. If a person says, I've been diagnosed with this, I'm serving a 50-year sentence, that's newly discovered evidence. I wasn't sick when I got sentenced. So now, according to this pleading, they would be entitled to relief. That's the basis that they cite in this particular pleading. The bottom one, Mr. King's case. The defense has not established that the petitioner would more likely than not have received a different verdict. They're acknowledging their burden and that they cannot meet that burden they're essentially trying to join with the defense here to meet the burden. They are saying, we know that in order to have this outcome, we have to be able to show that the verdict would have been different, and the defendant is not able to do that here. There remains ample evidence to show Mr. King participated in this offense. Now, they release him anyway, but that's their own language in the state's pleading. So again, when we come up here and talk about undoing injustices and wrongs of the past, we have to go to the actual pleadings filed by the state themselves as the basis of what they did. Not generalities, not Cliff Notes versions of what might sound good. It's what they filed. These are the actual facts in their pleadings and what they based the release on. Now, here's an example of just a few that we were able to locate. I mean, look, we had one over the weekend, so they come regularly. And this is interesting to note, too, before we get into the specifics of this. Of course, nobody disputes that there is a crime, that the crime has gone down in New Orleans, and we do credit that a lot to Troop NOLA and their efforts in the city. But you have to remember that
I will point out, I did look at the Metropolitan Crime Commission statistics, and the murder rate is still 20% higher than it was in 2019, pre-COVID, as of today, as of the end of August, actually. The stats go through August 31st.
Yes, we do not see a dramatic improvement in the murder. We are also still ranked number 3 New Orleans for violent crime in the country. So, I don't think anybody's throwing a parade down in New Orleans, which is where we live and where we're from. Well, we are. She's Jefferson Parish over here. But, that's the reality you have to also think about. When we talk about the release of 300 to 350 people, they're not going to recidivate the next day, the next month, the next year. We have to wait now and see. This is not even cases that the DA's office has refused in their screening process, right? So when you see that all over the news, last night, a woman was picked up and charged with a quadruple shooting over the weekend. She shot 4 people, 1 died. A murder by the office was refused on her, a second-degree murder in May of 2023. So those numbers don't even include the new decisions being made in current screening cases. These are just post-conviction cases. Here's a few examples. Henry Talley was convicted of second-degree murder in 1996. On May the 24th of 2021, the DA released him. On May the 11th, he got into an argument with his girlfriend, ran her over with his SUV, and left her dead in the street. Joseph Nora and Sean Watts. This is one that we just heard about yesterday, actually, is with regards to Sean Watts. Both of these are convicted of attempted second-degree murder in 2011. On February the 1st of 2022, the DA released them. Nora goes on to pick up a gun charge. In November the 14th of 2022, he gets murdered in a shootout. So he gets himself killed in a shootout in 2022. Sean Watts was just identified yesterday as a suspect in an aggravated burglary in New Orleans where he breaks into a home and beats the victim inside. So these are just some examples. Rashad Green and Leo Tate, both released by the DA, both pick up federal gun charges, one of them a machine gun. Both pled guilty to those and still remain in federal custody. So these are just a few examples of what we see on the post-conviction side. Okay, this case is Herman Evans was convicted of second-degree murder in a beating. It was a very, very brutal beating and stabbing of the victim. He was sentenced to serve life in testimony. Life in prison. In a rare scenario in Orleans Parish, and before we get into the weeds on this was a rare case where we saw an actual post-conviction hearing taking place. In most of the other cases that you will see, it was a pleading, joining in, and the guy was just released. This one is an actual hearing. They bring a guy in named Mr. Green. Mr. Green takes the stand and testifies that he was there at the time of the stabbing and that he was actually the one who stabbed and killed the victim. They admit that Evans was there, but that Green was the guy who actually stabbed him. After the testimony, the state releases Evans after the testimony of Green. During the testimony, the judge asks the ADA, Emily Ma, if she intends to now indict Green, the person who committed the crime. Ma refuses to answer. Here's the quotes from the transcript. This judge says, "The state has an obligation to do something with respect to the person who has confessed to an actual murder, and I think that is an issue." Ma's response, "I don't disagree with that, Judge, and we'll take that under consideration. I think the primary concern is addressing this." The judge responds, "No, my primary concern is the murder of the victim, and the murder of the victim needs to be addressed just as much as rectifying the purported wrongful prosecution of the defendant." Now, a couple of interesting points here. To this day, Mr. Green has not been indicted to the murder he confessed to. Something that should also be very troubling to you in this transcript was, if you're looking to protect the rights of Mr. Green here, he is not advised of his rights before he takes the stand and is led into confessing to murder. Now, he may have a promise from the DA's office that they won't indict him, but he does not have a promise from any other agency, statewide or federal. And he has no rights read to him on the record. There's no indication anybody warns him of what he is essentially saying under oath in regards to the murder. This is a transcript in court in one of these releases. Now, here's an interesting pleading that was filed days ago in criminal court. Eric Matthews was convicted of first-degree murder after he struck his 2-year-old with a belt until she died. After working with the defense to undo this conviction, the DA's Civil Rights Division was removed from the case. But it was too late to undo the release. ADAs from the Trials Division are now claiming in this state pleading that the basis cited in many cases by their own DA's Civil Rights Division is not a legal basis for relief. Okay, this is kind of hard to follow. So what happens is the Civil Rights Division in the DA's office goes into court with the defendant's attorney, Eric Matthews, and they say they start working on this release, and they waive certain delays, procedural objections they don't make, and sort of open the path for Matthews to be released. The Civil Rights Division is removed from the case, but essentially it's sort of too late. And you'll see this actually got coverage in New Orleans yesterday in the Advocate newspaper. So the Civil Rights Division is removed from the case, but the judge goes ahead and orders the release. Now, we have a pleading from his own office, his own DA's office, saying undoing that conviction was illegal. And that's another one. We talked about Ramos and Cage. This is another one to answer Senator Duplessis's question. Have you found anything illegal? We have an admission by the DA's office from one of their division against the other division that the actions are illegal, that the release is illegal. So this isn't even an outsider saying that. This is within the office. This is their actual pleading saying the court's reasoning with respect to ineffective assistance of counsel, coupled with the court's emphasis on mitigation information. What is mitigation information? That's the stuff like he's sick now, he's old, he's got a good jail record. That's mitigation, okay? Suggests that the court's decision to vacate the defendant's conviction is, in actuality, an illegal grant of judicial clemency. A usurpation of the power reserved only to the governor of the state of Louisiana. As such, this court's ruling is improper. The state requests the court reconsider and reverse its decision to vacate Eric Matthews' conviction for the first-degree murder of a 2-year-old. Okay? That is, I'll tell you this, the majority of the pleadings we saw raise ineffective assistance of counsel and mitigation. That's really the majority of what they're claiming. Maybe he could have had a better lawyer who would have asked different questions, who could have gotten him a manslaughter conviction. Maybe he would have had a better lawyer who asked for certain documents that would have made his guilt less than somebody else, and we could have put more blame on somebody else. So basically, this is their own pleading. This is the DA's office pleading, trying to undo one of their own actions. Again, and I guess you can see the highlighting through. Again, the court has engaged in an illegal granting of judicial clemency. This is basically, they're saying, what you're asking for is to undo a conviction based on mitigation. You feel sorry for somebody. That is a right reserved for the governor. It is illegal to do that unless you are the governor. It's a specific right reserved for him. Here's the article. This came out yesterday morning, basically saying that the Civil Rights Division that Williams created in 2021 cleared a path to the courthouse for Matthews. His attorneys and lawyers in the Civil Rights Division teamed up on language to waive time limits and other legal obstacles that allowed him to argue that his defense lawyer had failed him. That's our ineffective. And so they're now asking to undo it. So this was just from yesterday's paper. So we see a pleading coming out of his own office basically saying we need to start undoing some of this. There's a civil side to this as well. Here's one example. Tyrone Clofer was convicted of second-degree murder in 1986. He filed so many frivolous post-conviction relief applications that the federal U.S. Fifth Circuit wrote this in 2008. Clofer does not make a prima facie showing that his successive application is based on facts that could not have been discovered previously through the exercise of due diligence. Moreover, this claim is virtually identical to the claim raised in his prior application and will not be considered. Clofer is warned future filings or repetitive frivolous motions for authorization will invite the imposition of sanctions. So basically, the federal court is saying, stop filing or we will sanction you. You have no remedy, legal remedy left. What happens? In 2022, he files in the state court in Orleans Parish. They retroactively apply Ramos to this one. This is the non-unanimous. That's what they use for this one. And he's released. And what does he do right upon his release? He files a federal lawsuit against the DA's office, 2 former district attorneys, 8 former assistant district attorneys, and the lawsuit is pending. He seeks $1 billion in damages.
And I note that some of these people, these ADAs, have not practiced as ADAs in 30 years. They're from across the country.
You
They
need
have
to
no idea what this is
state your
about.
name before
Blake
you tell-
Arcuri. Some of these assistant district attorneys have been out of the practice of criminal law prosecution for 3 decades. They have no idea what this is about. They have 3 law firms involved so far that the state's going to have to pay for, these people are going to have to pay for, and there's still 5 ADAs to serve. So this could be a monumental deal that's going to last years waiting for dismissal of this for no reason.
And you have to remember, this does not include wrongful conviction compensation, which is a totally different avenue for defendants to seek payment from the state for what they deem is a wrongful conviction. Okay, here are just some numbers for us. How does this compare to other parishes? These are DOC numbers. For 2024, resentencing, Jefferson had 1, St. Tammany had 1, East Baton Rouge had 1, Orleans Parish had 42. And then we went over that number before, 349 since taking office. That should be a stark contrast to what we heard from EBR, which is about 5 in 5 years. So 349, I don't even know what the statistical difference would be there. There's another point that that we have on another slide, and if I need to put it up, I will. But one of the interesting things about the Civil Rights Division is that when this division started, and there's this whole sort of platform that this was going to be an important campaign platform, and I think that's what the senator discussed in questions earlier, that this is what this district attorney ran on. This was the platform. He said he was going to release people, and he's upholding his promise. And there you saw some back and forth about, well, you can't make a promise to break the law. That's not a promise we can honor. So it doesn't really matter what you promise. The law is sort of the law. And in retroactively applying some of these cases, we see their own office admitting that some of these practices are illegal. The interesting part about that is there is a secrecy around the Civil Rights Division. So instead of sort of touting this great record that he campaigned on, he refused to provide documents to the public in connection with the Civil Rights Division. He invoked a work product privilege, saying that people were not entitled to review the documents of the Civil Rights Division because they were privileged work product. Unfortunately, that was in stark contrast to an article published by The Guardian, who apparently got direct access to the DA's office for 6 months. In fact, might just work better to, it's this one, right? So here is I don't know how to do the full screen one.
Right here.
Basically, this is the article. This was in the Advocate article citing where the DA's office refused to produce the pleadings from the Civil Rights Division, and this is written not by myself, this is by a reporter from the Advocate, that Williams' office has described the withheld records as work product. Now, here we have The Guardian, who writes an article about how great the Civil Rights Division is for undoing all these wrongs, and they admit that for the past 6 months, the Guardian was given extensive access to the division, nestled in a corner on the 4th floor of the DA's office. So they had access to the records, but nobody in the public was given any access to the Civil Rights Division's records. So obviously, that's in stark contrast to any sort of campaign promise, is to keep secret what's been going on in the Civil Rights Division. I think, Chairman, if you have any questions, I know it's been a lot.
Thank you for your presentation. I do want to hear from Representative Villio, but we do have a question by Senator Duplessis.
We can wait.
Okay.
Thank you, Mr. Chairman. Senators, it's a pleasure to be with you this morning, a little bit sooner than I expected, but Mr. Chairman, I welcome the oversight. And I really appreciate Ms. Rodriguez's thorough presentation. Certainly don't have much more to add to that. I've done my own review. In the last 2 weeks, I've probably spent over 60 hours reviewing many of the cases. What I'm missing are the court records in these cases, and for that reason, I am going to refrain from comment on specific cases. What I will tell you is, as a former prosecutor, this is just not what we do, and it is seriously troubling, and it should be troubling to all of you. And Senator Duplessis, it should be troubling to you as well. The ushering out of a volume of convicted murderers and other violent criminals in the weeks and days leading up to August 1st is not in keeping with a prosecutor's duty under the law, in my opinion. I welcome the oversight, Mr. Chairman. I welcome any participation that I can add. When Senator Duplessis talked about expertise, I certainly think since my role, I never thought I'd give up prosecuting. And it certainly, I am a prosecutor at heart. But I am happy to be in the legislature, and I'm happy to help in any way I can in reviewing these cases. And once I do my own review, I'm happy to comment on the specific cases.
Thank you very much,
Thank you.
Representative Villio. Senator Duplessis.
Thank you, Chairman. Chairwoman Villio, thank you for being here. And I guess I'll start with just addressing your most recent comment about my concerns. I'm concerned about all of these issues just as much as you are. I just want to go to the last comment that you made, which was that you don't believe that the actions that were taken by this district attorney's office were keeping in line with the duty of a district attorney under the law. That's what you just said.
In many of the cases that I've reviewed, I am very concerned.
Okay, but you said that he's not keeping in duty with the DA's role under the law. Why not? What law was violated?
Senator Duplessis, the legislature makes the laws, the procedural laws.
Right.
And a district attorney is duty bound to follow those laws. Now, again, I don't have.
What law was not violated? What law was not followed?
Okay, I think
I'm just.
you're
It's a statement that you made.
No, sir, Senator Duplessis, you're trying to bait me into commenting specifically.
That you made.
When you're finished, I respect you as a senator. When you're finished, I will.
Chair,
I will continue.
Let Representative Villio finish responding to.
What I said was what I'm seeing is very troubling, and whether or not the law has been followed, but I am refraining from specific comment until I have the actual pleadings from the files.
I respect that.
And that's why I am not going to go down that road. I'm not going to accuse the DA of doing anything until I have satisfied my own review. But if my review is satisfied, once I review these pleadings, the pleadings that are filed, and the other information that I am receiving, then I will comment more specifically.
Understood. And I just want to just state again, I respect you refraining from commenting until you have further information.
Sure.
But prior to saying that, you said that you don't believe that the DA is keeping within his duty under the law. That's what you said. So I don't know how to reconcile the two, but I respect you're not going to refrain.
I don't know. I would have to do it. We could have somebody read back what I said specifically, because it's not my intent until I have the facts. We deal in facts. These cases deal in subtleties. That's what we do as lawyers generally. And so that's why I'm not willing to comment on specific cases and facts, because I haven't had that review. I haven't been able to access those pleadings.
And just to clarify a few things, first of all, Ms. Rodriguez went to the criminal district court clerk's office to try to get the documents, and the pleadings are not readily available at the clerk's office. She was able to get some, as I understand it, and then more documents were provided by Mr. Williams to the Attorney General, and we were able to get them from her. So Ms. Rodriguez has had access to these, whereas Ms. Villio has not had access to these, as she was doing her review prior to our receiving these documents. So she was going through simply the docket master, as I understand it, which is a basic summary that are minutes of the court that are not explicit and don't have the actual. Whereas Ms. Rodriguez was able to get a lot of these documents. She spent a good bit of her own money extracting trying to extract these documents from the clerk of court's office, and then was able to get additional documents indirectly from Mr. Williams. So I think if that helps explain why she's refusing to do it until she's a very experienced prosecutor, and she's not going to say something until she's seen it with her own eyes.
Well, I mean, I can answer that. I think it's right here in his own pleading.
Thank you, Madam Chair. I appreciate you, because look, Ms. Rodriguez, you said a lot. You shared a lot of information, more information that I'm sure Mr. Chairman is going to give me an opportunity to go back and try to question. And, in terms of a time standpoint, I'm sure he's going to tell me I need to wrap it up at some point. So let me just kind of get to some basic questions that I have.
Sure.
The first being the fact that there's been a lot of emphasis on factual or actual innocence in many of these cases for post-conviction relief.
Emphasis by who?
By your presentation.
No.
There is a
lack of
actual
innocence.
Exactly. So let me get to my question.
Okay.
So there's been a lot of emphasis around the question of innocence, as opposed to, from a post-conviction relief standpoint, as opposed to other factors, right? There are other factors that can lead to post-conviction relief. Brady violations, ineffective assistance of counsel, something went wrong at the trial, not the issue of actual innocence, correct? There are other instances.
Court, as the AG testified, there are factors set out at different phases of post-conviction, and at each different phase, the court will outline very clearly what remedy you have. What are your options
but
for
there are other
post-conviction?
factors outside of just innocence that can lead to post-conviction relief, right?
Set out by the Supreme Court in both state and federal. Yes.
Right. Okay. All right. Just want to make that point, because it seemed like most of the cases that you cited were going to the issue of, or the question of, innocence. In much of your presentation, you cited Orleans Parish as being an outlier with respect to the post-conviction releases that have taken place within the last several years under this administration. There was even talk a lot about the multiple bill, habitual offender law.
Correct.
That Louisiana is well known for. Orleans Parish was very well known for that, right? So
Under who? At what time period?
Okay, specifically under the Canizero administration. I do know that over a stretch of 7 years, I don't know the exact number of years, or if you were there at the time, because you are a former prosecutor, right?
I am.
And you worked in that office, correct?
I did.
Okay. Over a stretch of 7 years, there were 2,700 uses of the multiple bill, the habitual offender law, in Orleans Parish. But in East Baton Rouge Parish, over that same number of years, it was only used 60 times. Why was there not a Senate hearing called in that instance?
Well, I would ask you to ask. You're the representative, right? Are you the senator? When were you a senator?
I didn't ask for this hearing. So I'm trying to
why didn't you ask for one about that?
I'm asking you.
To be fair, you did ask to participate.
I'm asking.
Even though you're not on the committee.
I'm asking. I'm asking the question because I'm trying to make a point. Right? It's like we're trying to be selective about where we want to highlight differences.
Well, actually,
there was a difference. I'm asking my question. There was a difference in certain policy decisions that were being exercised by a previous administration that didn't seem to warrant a Senate hearing being called. There were other policy decisions like fake subpoenas being used, other issues that actually may have violated the law. And I don't recall any Senate hearings being called. So I'm trying to go back to why we're here today.
Yeah, I think that's an excellent point, because the prior administrations weren't violating law. That's the main difference.
Where is the current administration violating law?
Do you see where they wrote it in their own pleading? It is right in front of you, or on the side of you, on the screen.
Well,
they're issuing.
They're going to have an opportunity to speak
Senator,
to that. I think the DA's office will have an opportunity.
I'm sure they will.
So
What I'm
if they
saying
violated
is, you're
the law,
specifically asking me
if they violated the law, what court has determined that? What court has determined that they have violated the law?
I think that's to be seen. Aren't we here for that?
So, well, that's why we have the process, right?
Correct. And if you had a problem with a prior administration as an elected official in Orleans Parish, I assert to you, why didn't you speak out?
No, I think the voters spoke out.
My dad did not run for election against Jason Williams.
Why not?
He took another job. He moved on to the Attorney General's office.
Okay,
and
let's get beyond the personal stuff.
Yeah,
ask a question and let her answer, and then we'll move on.
Okay, let's talk about the case law, the case law and the retroactivity argument.
Okay.
You started your presentation saying, basically making us believe, or try to make us believe, that because the case law did not specifically say that DAs were not required to apply it retroactively, that they could not apply it retroactively, which you and I both know to not be true.
That's
did anything
false.
in the case law, Ms. Rodriguez, did anything in the case law say that they were prohibited from applying it retroactively?
Absolutely, and I would expect you to know that as an
No,
attorney,
ma'am.
Senator. As an
I did not
attorney-
see that anywhere. I did not see that anywhere in anything that you cited.
The Attorney General testified to this.
Just because somebody testified to it doesn't mean that's what the court said. And I didn't see it anywhere
I guess then,
in any
if
case
you're
law.
implying that the Attorney General just lied under oath, then maybe you should call a separate hearing for that.
No, ma'am. I'm asking. You're citing what the AG said. I'm saying I haven't read it in any case law that you have cited or that the AG has cited that said that DAs were prohibited or that they were restricted from applying it retroactively.
It is appalling to me that you would assert that in public on this particular matter
Give me
when
the
the
basis.
DA's office has put it in their pleading that they know they cannot apply this retroactively. And as an attorney, and you're representing Orleans Parish, Senator, you
Yeah,
represent
I'm
Orleans
proudly-
Parish, and you're telling me that you are not aware that it was decided that Ramos cannot be applied retroactively.
No,
is that your assertion?
No, ma'am. I'm the one asking the questions. So I'm the one asking the questions, and you're misinterpreting my question because you're pushing an agenda. You're misinterpreting what I'm saying. The not being able to apply it retroactively, that's not what I'm saying. I'm saying that the DA is not restricted from applying it retroactively.
Well, then-
we're talking about under the DA discretion under post-conviction law.
Okay.
So you're trying to twist up what I'm saying.
Listen, I think that's fine. I'd like for the record to reflect here that Senator Duplessis believes that
No, ma'am. No,
the
ma'am.
DA
See,
has discretion
no,
to
no, ma'am.
retroactively apply
No, ma'am.
Ramos
This is-
against the ruling
No.
of the
Mr.
United
Chairman,
States
point of
Supreme
order.
Court and
Point
the
of order.
state
This is
Supreme
outrageous.
Court.
Point of order.
And this is our Orleans Parish representative.
Mr. Chairman, this is.
Y'all are arguing a fine point of law. You suggest that the DA, and
I'm
that's not going
suggesting
to, that's not going to be.
that the DA still has discretion.
I understand.
And nothing in the case law restricts the DA from what was agreed to in these post-conviction decisions under the case law.
And she suggests otherwise.
And I think some of the comments that are being made about who I represent or what I represent, I think we're getting a little off base with that. So I'm asking the chairman to kind of.
I think we're getting off
Yeah,
base a little
completely.
bit. But there's enough blame to go around on that. But maybe the Attorney General wants to answer this question. So
I just have one statement. I mean, I think that the Louisiana Supreme Court ruled recently that a statute that allowed the district attorney, the judge, and the DA, and the defense attorney to agree to reform a sentence was unconstitutional because it violates the clemency powers of the governor.
That would
So
make
I
it
think
illegal.
If it's unconstitutional, you can't do it. So there are limits on the discretion that the district attorney has. He does not have the constitutional power to do what the Louisiana Supreme Court has said he can't do. And so I think that it is not correct to say that he has this absolute discretion to do anything he wants, even if there's no justification in the law.
Never have I suggested that.
Okay. Well,
Never
then-
have I suggested that. So I didn't say it when you were at the table. I didn't say it just now in my question to Ms. Rodriguez. So
Okay.
let's not get into that. Let's not try to say I'm saying something that I didn't say. What I'm saying
not.
is that
I'm just saying
the
that's where I think the
interpretation
limits are.
of both the state and federal law, my understanding, and forgive me for not being the legal scholar that you are, Ms. Rodriguez, but my understanding of the case law does not prohibit a DA from still entering into these agreements with the blessing and agreement and with the approval of a judge. Ramos simply said it's not automatic. It's not mandatory that it apply retroactively.
So I disagree
well, okay. Well,
with that
let's-
interpretation of what
Okay.
the authority is of the
let her
DA.
answer. Now, you've made your point, and she's trying to answer, and you're interrupting
Disagree.
her.
We disagree.
I mean, it is not within his constitutional authority to do that. That's what the Louisiana Supreme Court said in the Lee decision. So you can't just do anything you want. There are constitutional limits on what the district attorney can agree to or the judge can do. When it's not constitutional, it means it's not within his power to agree to that
So where did he violate the law?
by doing something that's unconstitutional.
Okay, so earlier when I asked you that very specific question, you said that he had never violated the
No,
law.
that's not what I said. I said that
Okay.
there are constitutional limits on what he can do. He does have, any district
Okay.
attorney has broad discretion, but they still have to act within their constitutional powers.
So, Ms. Rodriguez, you were a district attorney. You served in Orleans Parish. You were an assistant district attorney. During your time at the district attorney's office, did you ever enter into any of these post-conviction agreements and releases, as you like to call them?
As I said in the beginning, I was exclusively assigned to the trials division, so I did not handle post-conviction relief in the appellate, which is typically assigned to the appellate division. It is now assigned to the civil rights division.
Did it ever
Let me
take
finish.
place?
I am 100% sure that there were post-conviction agreements made under the Canizero administration, under the Kiva Landrum Johnson administration, under the Eddie Jordan administration, under the Harry Connick administration. These agreements are made in, I would venture to say, probably almost every DA's office in the state. That is why what triggered this particular review was the insanely disproportionate number coming out of Orleans Parish. So as you heard, a comparable parish, EBR, East Baton Rouge, one a year. We see that statistic is consistent this year in 2024. So one a year is the average of other DA's offices. Our DA's office under the Canizero administration, and I worked under Kiva Landrum as well, of course, had to enter into post-conviction agreements. It was years of litigation, months if not years, of post-conviction litigation, hearings, testimony, briefing, filings, contacting witnesses, old detectives. All of those sorts of things is a lengthy process that goes on in post-conviction. And it's absolutely something that district attorneys have to do. They have to evaluate, and they have to make very difficult decisions.
Okay.
But we expect them to do it in accordance with the law.
Okay. All right. I feel like things have shifted from there having not been a violation of the law to now there being absolute certainty that this administration has in fact violated the law. So I'm hearing a lot of different things that are coming from that table.
I think this record will be clear.
What is your goal? Are you here? You're in your capacity as what? As a citizen?
Citizen.
A concerned citizen.
I am a resident of Orleans Parish.
Have you spoken with your locally elected representatives? That
They have reached out.
The people that you actually had the power to elect. Because I don't think you voted for anybody on this panel. Did you reach out to the people that you have the power that in local government, like your local city council who helps fund the DA's office? Have you reached out to the DA's office?
We did reach out to the city council, and unfortunately, there has not, and really, it's a sad day for Orleans Parish in general, that there is no more discussion. There is an ignoring. There is a sort of
the DA's office?
turning a blind eye to what's been happening in the DA's office.
Did you reach out to the DA's office?
Not to the district attorney, no.
So we're
Not
here.
to Mr. Jason Williams, no.
So did you reach out to the DA's office?
I have spoken with assistant district attorneys in the office now and past ones.
But you never requested a meeting or a discussion with your elected DA who represents the district attorney's office in Orleans Parish?
No, I have not requested a meeting with the DA.
Why not?
Well, I think that when we get information and we gather the information and then we present that information, then what happened in this particular case was he went on TV and he said that his justification for this was undoing the wrongs of the past. And that's when I knew what his response was. This was what he said was the reason he has released 300 to 350 people in Orleans Parish. Now, without letting the public know, because the records have been kept under a privileged work product exception that doesn't exist for closed files. So
Okay.
with his response,
So
then
that was
I
enough
said,
to not
let me
reach out to the
start-
DA's office.
Okay,
course,
we're
Senator,
not
I already
really
answered
talking
that.
about post-conviction relief anymore. We're doing a he said, she said thing. So let's stick to the issues of post-conviction relief, not who asked for what meeting and who met with whom. Let's find out what needs to be found out about post-conviction relief.
Chairman, respectfully, I have a reason for asking that question, and my reason is we're not here to waste time. if we're here to just put on a show, that's fine.
Well-
But I'm trying to get to the solution. And if we're serious about solutions, anybody I think who's really serious about working this out and getting a solution will have reached out to their DA, not created where we are today, where we know the cameras are going to show up to try to push a political agenda. And that's my concern, is that we're here more so to push an agenda as opposed to actually getting to solutions. So that's why I'm asking the question.
Well, I called this meeting, so now you're attacking me.
No, sir, I'm not attacking you.
Okay, wait just a minute. Wait just a minute.
No,
Wait
no,
just a minute. No, you're.
So did you call this meeting?
I called this meeting myself with the consent of the President of the Senate. And I did so because of these cases that we just saw a recitation of that would potentially lead to a concern for public safety. This is not a political move on my part. I'm from North Louisiana.
Correct.
And you're from New Orleans. I get that. But New Orleans is important to the entire state. We just heard that the state is going to get sued for these people being released, number one. Number two, those of us who live outside the city have to go to the city for business. I have more business in Orleans Parish than I do in Ouachita. It's important for the entire state to go to a safe city, and it is not a particularly safe city. And that's why we're here today, not to push a political agenda, but to get to the facts to find out if there's a way to make it a safer city. And that's the reason I'm here. Thank you for your questions. I'm going to go to Senator.
I have a few more questions.
I'll get back to you in a minute, but we're going to let everybody have a chance.
Rodriguez got to present for a very long time, Mr. Chairman.
She was here as I requested, and you're here at my indulgence. You're not a member of this committee, and I will let you testify. I will let you testify.
She really belongs to another committee.
That's debatable, but in any event, I'm going to go on to Senator Hodges. Senator Miguez is next, and then Senator Hodges, and I'll come back to you. But I don't want you running the clock on this meeting. So
I'll be here all day.
I know, but other people have other obligations, so I'm going to respect their time. So I'm going on to Senator Miguez. I'll get back to you if we have time, but we need to stick to the points. Senator Miguez.
Thank you, Mr. Chairman. Ms. Rodriguez, I'm senator myself from New Iberia. I want to understand what's going on in New Orleans. We talked about public safety. That's the main charge of our criminal justice system and our district attorney, correct?
Correct.
Is there a different definition in New Orleans than the rest of the state?
You would think so by seeing what we've seen today, but legally, no. It is applied the same throughout the state of Louisiana.
Senator Duplessis talked about the voters, 60% of the vote, decided to go in a different direction, but then he also said that it was to support public safety. You are a resident of Orleans Parish?
I am.
Tell me what direction he was referring to, or you believe he's referring to as a citizen of Orleans Parish. And do the people of Orleans Parish agree with your presentation and what's going on there?
I think that the people of Orleans Parish, we see, and I don't have to speak for the people of Orleans Parish, I can speak for the victims in these pleadings who spoke for themselves, who came in, some of them more than one case, I know of 2 cases offhand, who had to hire their own attorneys. Victims in Louisiana should not be required to hire an attorney. They are represented by the state of Louisiana, the district attorney. These people had to hire their own attorneys to figure out what was going on. There is indication in the pleadings that they were misled on some reasons for release, believing that there was a legal basis that they had to release people. That was not true. So I think that the victims speak for the residents of Orleans Parish when they say we're not okay with these releases. I think a judge in Orleans Parish speaks out in this transcript and says, this is extremely concerning to me that somebody's going to confess to murder and everybody's going to let him walk right out of the door, and we just basically put him up here to get the other guy out. So we see the people of Orleans Parish speaking out in these pleadings. It's really a shame that in Orleans we do have to rely on leaders that are statewide to come in and say that's not going to happen anywhere in the state. We do heavily rely on statewide leadership. And most of you would look at us and say, it's your problem because you choose to live there. You live in this city, so you have to accept what that city brings. And I was born and raised there. I haven't left yet. I think that there are legal parameters that are required statewide. And when they're not met, we have to come here and rely on statewide leaders to speak up for Orleans Parish. And that's really the only chance we have of the public understanding what's going on and for there to be some oversight, some transparency, and some accountability.
Thank you. We kind of get the message, and I would like to move on to, unless you have another specific question, move on to Senator Hodges so we don't run out of time here.
Yeah, I have a few more, but maybe I can run through them very quickly, and we'll try to keep the answers as quickly as possible.
Keep it very quick.
So Senator Plessis also mentioned that the judges are involved. It's not just the district attorney's office, but the situation with the attorney general mentioned to us earlier, when you have the district attorney as not an adversarial party, what kind of position does that put the judge in?
That's correct. And that's been an issue that's been expressed, that the judges are basically two defense attorneys are coming in each case. So they have nobody, and I think the AG spoke to that.
So you don't have anybody really speaking up for the states and taking a public safety position.
Correct. And in response to Mr. Duplessis's question, too, doesn't a judge have to be involved? No. On a dismissal, they do not. The DA's office can walk into court, write dismissed on a bill of indictment or a bill of information, and that's it. There is no judge involvement in that at all.
And we'll move through this rather quickly. Also, there's been numbers put out that 42 cases this year of resentencing versus East Baton Rouge Parish, one case. There's been 350 cases of resentencing since he's been elected. Don't you think that's a major red flag there? I mean, that requires us to investigate further. I know there'll be more information that's coming out, but that's just a red flag in general. That doesn't seem like, how do you justify that?
I think that is really the basis of why the committee will eventually have to take a look at that. Most DAs, most people will never see that number in their lifetime. I mean, a DA will certainly never see it in his or her lifetime or their tenure, no matter how long they serve. We would never expect to see that in a few years.
The chairman mentioned he conducts a lot more of his business in Orleans Parish, the importance to the state. But I also want to point out, as being a member of the Finance Committee, the amount of money that we are investing locally into Orleans to fight the crime problem there. I would like to use the word tens of millions of dollars, but it's probably up to $100 million now. And the reason we're doing that is because we're trying to help citizens like yourself in Orleans Parish get the crime situation under control. But is it really the responsibility of the state to come in there and manage your local crime issue? It's a must. We have to do it to stabilize the scenario. But we are spending a lot of money there. And the reason we're doing that is because it's also a national tourist attraction, and we're trying to maintain our asset and keep the people in that area safe. But I want to make a point that we are investing a lot of money there. And I want to close up quickly because I know the chairman has a limitation of time, but I do have one point of order for him. Mr. Chairman, there was some information in their presentation towards the end where some of the information from the district attorney's office has not been readily available so we can determine whether laws were broken. Has our committee submitted a request to the district attorney's office?
Yes, we have, and we'll when Mr. Williams comes to testify,
okay,
we'll speak to that. Let's move on. Thank you, Senator Miguez. Senator Hodges, you have a question?
I do. I just want to say thank you for being here, and I want to thank the chairman for calling this meeting. Thank you for your very disturbing presentation. It brought tears to my eyes. And I think it should concern all of us, but to hear that those are factual things that actually happened. Crimes by sick people that is so wicked beyond comprehension for us to think, and they were let out. These were not accidents. This was not manslaughter. When you chop up somebody with a machete, that's unthinkable to us. But yet, these are the types of crimes that we're talking about, finding some loophole to let someone out on. None of us should support that because it is evil and it's wicked. But the question that I have for you, I believe I noted in your slide presentation, most of these, the Civil Rights Division was involved in most of these. And my question for you is, do these, I don't know how many DA's offices have civil rights divisions, but are these civil rights divisions funded through supplemental pay of the legislature? How were they actually funded?
I do not know how they are funded. Orleans Parish is the only district attorney's office in the state that I'm aware of that has a civil rights division, and maybe somebody from the LDAA could say differently if that's true, but the only office that I'm aware of in the state that has a civil rights division is Orleans Parish. This civil rights division the head of it is Emily Maw. You saw her name. She is from the Innocence Project and a career-long defense attorney.
So that's the only one in the state is that you know
That
of?
I'm aware of. Is it? It is.
So we need to find out how this is being funded, because they blatantly ignored the cries of the victims. And we heard many, many cases in Jude C during our session on crime of victims. And you guys remember how horrible we cried of some of the victims that testified about clemency hearings, that the perpetrator was let out after murdering their 3-year-old or was going to be let out. And so these are and this is an organization that is fighting to let out this kind of people with giving no voice to the victims' families. And so I want to say thank you. I've just got one other question. And so we're here to determine if in what you said, and I'm not an attorney either, but I can read what the Supreme Court said about Ramos, the Ramos case, that you're not supposed to go back and do retroactive, which they clearly did. And I guess we'll have to determine that. Is that a fact that they did go back and violate that?
They absolutely. I mean, the slide that was up is basically they filed several motions in cases where they applied Ramos retroactively. They said it was a non-unanimous jury, but it was from decades ago, and they applied Ramos after the Supreme Court had said it cannot be applied retroactively.
And then, in your opinion, as an attorney, what's the next step?
So I think that the review, or a more thorough review where documents are provided, that a committee can review those and come to a determination on, like, we certainly know this on these particular cases. And then there needs to be a discussion among the legislature. Is more legislation necessary, whether that be an oversight legislation or whether the legislation as it pertains to post-conviction relief in particular be added? But I can tell you that these releases are not confined to just post-conviction, because some of them don't file a post-conviction pleading. They'll just go in and file motion to correct an illegal sentence. That would not be protected by the new legislation. So whether legislation be something that is brought by the legislature, in terms of undoing this, that's like the expression, it's kind of hard to put the toothpaste back in the bottle, and rounding up 350 people who were released and bringing them back in. That I don't think that would be likely, given the magnitude of that, and I guess that would fall on the shoulders of the Attorney General. I don't know how she would ever be able to take on a task like that, but those are some possibilities.
Policy responses will come next year.
Mr. Chairman, if I can just address Senator Hodges, I'm not sure if her question implied that all of these cases or releases may be relative to Ramos, the retroactivity of Ramos, and I just want to make clear that the cases I've reviewed, that would be far from the case. In fact, while I'm not going to talk case specific, there are instances of first-degree murders where they went to the penalty phase, which means in order to do that, that was a 12 of 12 jury that found the individuals guilty of first-degree murder. And when they deadlocked in the penalty phase, then they were sentenced to life in prison. And some of these cases over this year and leading up to 8/1 involve first-degree murder convictions where the jury deadlocked on the penalty phase. So we're certainly not talking about just Ramos.
Right.
And I just wanted to make sure.
Those are the most concerning.
I just wanted to make sure you were clear that Ramos is just one of the reasons you may hear used, but that's not.
Involving the $1 billion lawsuit, I believe.
Yes, correct.
Right.
Correct.
Thank you. Thank you. I'm going to go back to Senator Duplessis, but I'm going to ask for a 2-minute time frame because Mr. Williams is here and he's waiting to testify, and so he's coming next.
Thank you, Chairman. I just want to do a quick follow-up on Senator Hodges' question with respect to the path forward. So we obviously have some disagreements in the interpretation of law. We have some disagreements in policy. We have some just disagreements. The path forward and the role that we play here as a legislature, as a committee, whether it's Jude B, whether it's Jude C, whether it's the entire Senate or the House with Madam Chair, when we think about what a policy response would look like. I heard the term oversight being used. Could we possibly, Mr. Chairman or Ms. Rodriguez or whomever wants to answer, talk a little bit about what a practical policy response might look like to the concerns that have been raised? From a, like, what could a practical policy response look like? Because I don't think that we are here just guessing. I think that people who are here today probably have something in mind in terms of a direction that they want to go. And I just think we should start to talk about what that looks like from a practical standpoint.
I think that comes later, honestly, because as I said, I anticipate multiple meetings. We could spend all afternoon talking about possible policy alternatives.
Will we be working with the District Attorneys Association at all on this?
Yeah, I plan, and I've got some of the district attorneys are going to assist in our analysis. However, the District Attorneys Association that you read from their bylaws, of course, they are, and I respect them, and I got a lot of friends in the room that are district attorneys and members, but their job is to protect their own turf. And it's like they lobby for their group. So, no, I'm not going to defer.
No, I didn't ask if you, I said we were going to work with.
Yes, we'll be working with them. But I have, and that's a whole nother story, because I attempted to work with them diligently, and I think they will concede that in my policy initiatives, which they were against and fought back on, I made every effort to offer some sort of compromise, and none was able to be reached. But that's for a different day. We don't have time to go into all that. But I appreciate your line of questioning. We'll certainly include you in any purported proposed policy responses. But right now, we're trying to get to the bottom of what's going on here. So thankfully, the board is clear. If you all can step aside. Mr. Williams, you ready to come visit with us for a minute?
Beg your pardon, Mr. Chair, just getting set up here.
I understand you got Mr. Terrell with his big knees blocking you behind you, I see. Thank you. If you would introduce yourself officially to us, along with your, I see you have some staff with you.
Yes, sir. Mr. Chair, members of the committee, my name is Jason Williams. I'm the district attorney for the Parish of Orleans. I'm joined by team member Tim Browning and team member Micah Ince. Let me just say, as we start off, I think it's really clear that we are here because of certain misunderstandings, I thought. But after listening to the last presentation, I think that's better put. We are here after a misleading. Pronouns were used. They did this. They filed this. They were released. And we're officers of the court. We're lawyers. And we can't dabble in gray areas of they doing anything. Everyone has a role in a court of law. Defense attorneys file briefs. Judges conduct hearings. And the district attorney is on the other side of that V. The district attorney's office has been delivering justice and accountability in the city of New Orleans, and we are seeing the fruits of that labor. Public buy-in in the justice system in New Orleans is up, and violent crime is down. I know that Ms. Canizero would love to suggest that crime just went down, but crime started going down in the beginning of 2023, and it was no accident. I'm very proud of the work that this office has done on every floor, in every section of court, of the courthouse. And I'm very proud of the smart public safety partnerships that we built in my 3 years of being DA. Nationally, our federal partnerships are stronger than ever, specifically with the Department of Justice, U.S. Attorney Dwayne Evans, the ATF, the FBI, and the United States Marshal Service. This time last week, I was personally cross-examining a murder defendant, Preston Higgs, in Section E of Criminal District Court. We tried and convicted a brutal axe murderer who led us and the U.S. Marshal Service on a 4-month-long fugitive manhunt across multiple states, Minnesota, Illinois, Iowa, Alabama, and Tennessee. Big thank you to Marshal Brian Fair for his efforts working with us to track this person down, collecting evidence every step of the way so that we could hold him accountable, and he'll be spending the rest of his life in jail for the murder of a beloved teacher, Elizabeth Quackenbush.
Thank you for that.
I was with the ATF. Thank you, Mr. Chair. I was with Alcohol, Tobacco, and Firearms Special Agent in Charge Joshua Jackson on yesterday. We have been working strategically and surgically to go after drug peddlers and illegal gun dealers in New Orleans. That partnership has assisted us in doing something that prosecutors, mayors, and parish presidents have struggled to do historically in the state, which is shut down problematic businesses that are fostering and breeding criminal activity. Our partnerships on the state level, we have engaged in the most robust partnership that has ever existed between the governor, the attorney general, the state police, and any parish in this state. We did not let party affiliations or national politics get in the way of public safety at home. We are communicating on a regular basis and meeting and focusing on decades-old problems for the benefit of Orleans Parish and for the benefit of the state of Louisiana. And we've created a model that could be replicated in other parts of the state with Troop NOLA. To your point, Senator Miguez, I know the rest of the parish doesn't want to work on and spend money on fixing New Orleans' problems, but I think we all realize that New Orleans generates a lot of money for the state. And if New Orleans is healthy, the state is healthy. And I know that Troop NOLA and spending that amount of money can't last forever, but it can create a model that can go up and help Washington Parish and Bogalusa and other hot spots so we can get things under control. Locally, the partnerships have never been stronger. The City Council and the NOPD, these relationships are tighter than ever. I came from the City Council, and Chief Kirkpatrick has been an amazing partner. My office right now has former NOPD Police Chief Michael Harrison and NOPD Police Chief Michelle Woodfork on our team, giving my office more firepower from law enforcement than it's ever had before. Michelle Woodfork was a partner to me in bringing down violent crime in the city of New Orleans faster than any other city in this country and any other parish in this state after the surge in violent crime after the global pandemic. Her work internally, working with former CIA, FBI, and NSA agents to build stronger cases against the most violent offenders is earning national attention. These federal, state, and local partnerships are unprecedented in this state and in this country. Innovative collaborations with business and local nonprofits like the NOLA Coalition and No Dice are working to reduce crime and prevent new victims from being created. All in all, what I'm saying to you, Mr. Chair, I'm going to jump right into the heart of the matter in a second. I work to pursue public safety and public buy-in through addressing past harms is absolutely working, and we have the public safety numbers to prove it. And I want to welcome you, Senator, to come to New Orleans, not just read the files, and you, Senator Cloud, and you, Senator Klein-Peter, and you, Senator Miguez, and Mr. Senator Plessis, you know the city, and Senator Abrams, I want you to come. And I'd like for you to sit in during jury selection in the next murder trial that I personally try. So you can hear from our potential jurors when they say they cannot sit in judgment because of the number of times that the Orleans Parish District Attorney's Office has gotten it wrong. They don't believe they can convict because of the errors that have been made in the past in my city. I created this Civil Rights Division because my jurisdiction is an outlier in past defective convictions. And that has sunk public trust in our system, which has made it harder to prosecute violent crime and historically made us less safe than other parishes. We can only have public safety in New Orleans when people believe that the justice system is working for everybody in every neighborhood.
Okay, since we're approaching the lunch hour, I feel like we need to get in the middle to the heart of this.
Give me 30 seconds to jump into it. I promise I'll get to it.
Okay, because I've got some questions, and I know the committee's going to have questions.
Promise I get to it.
Sure.
What I just described, that trust is present in your districts. Senator Morris, your prosecutors all have the trust of their people and their jury pools. In New Orleans, we have a harder relationship with this. Predecessors in my office have contributed to that, including some of those who were just at the table slamming my efforts. New Orleans has been known for injustice for quite some time, and I'm just really trying to clean up that reputation as it relates to constitutionality and equal justice under the law. We have won some very difficult cases in the past 3 years, not because we have some massive police force now or some huge roster of prosecutors. No, it was because my lawyers can go anywhere, any high-rent high rise, or low-rent motel, and people are going to trust my ADAs, and they're going to cooperate because they know we care about getting the actual bad guy, not just someone who looked a little bit like him. Witnesses are coming forward to help us prove cases. People are actually proud to be a part of public safety in communities where they were not before. And we have the biggest drop in public safety to show for it. We had the highest rate of imprisonment in the world. We had the highest per capita wrongful conviction rate in the world. We had the highest rate of people serving life and parole in the world, and the highest exoneration rate, meaning an innocent person was sitting in jail when the convicted person was left out in community. And when we had those times, we also had the highest rates of violent crime. So New Orleans has proven that over the past several decades that more people in jail does not make a safer city. And I just hope that I get as much time as Ms. Canizaro had.
You will, except that we've run so long that I don't want to end the meeting prematurely because there are a lot of people that want to say some things. So, thus far your testimony is appreciated, and I understand your position on what you allege are past wrongs. Nonetheless, we're here to talk about post-conviction relief and what has happened in the last couple of years. So I'm going to jump into some questions. You have a staff of how many in your office? 150 or so?
More than that.
Between 150 and 200?
Yes.
And how many attorneys do you have?
We've got
roughly
2 per all 12 sections of court, 6 in juvenile, 3 in civil rights. I'll tell you, we don't have enough.
I see. And you have a division for felonies, a division for post-conviction relief, or a division for how is it divided?
So when we found ourselves with spiking violent crime and the murder rate was going up, I went to the city council and I asked them to help us fund a homicide unit where we recruited and brought in the most talented folks we could find to build out a homicide unit with folks who could try those cases, and we've had huge success with that. We built a SACA unit, which deals with special victims or sex crimes units. It deals with crimes against children and other sexual assaults. We have the appellate division. We have the civil rights division.
What about post-conviction relief? How is that handled?
Post-conviction reliefs are handled in the appellate division as well as the civil rights division.
Okay, those 2 areas handle that. And do you have policies and procedures relating to post-conviction relief of any sort, including motions to re-sentence, et cetera?
We handle cases on a case-by-case basis, and we make sure that everything is handled in the policy is that things are handled on a case-by-case basis, and that matters are handled in open court as it relates to any post-conviction.
Do you have any criteria or written memoranda, internal written policies on how your staff is to handle requests for post-conviction relief?
Yes, Senator, we have policies that make it very clear.
They're written policies.
Yes, and we'll share those with you.
Okay, and you'll provide those?
No problem.
Okay. Are they policy manuals or just memorandum?
Correct.
Okay. You have both? And who enforces those policies?
I do.
Do you review each and every request for post-conviction relief in a situation where your office agrees with the request for relief? In other words, where you go in and concede, do you look at each one of those?
I do, but I think I need longer than a yes or no on that particular question, because oftentimes, and this was absolutely molested and maligned by the last presenter, there are a number of post-conviction relief applications in which we assert procedural bars on a regular basis. There are a number of post-conviction matters which we fight to the hilt. And we sometimes lose those matters, meaning a judge has granted a new trial. And when a judge grants a motion for a new trial or grants post-conviction relief, that can put a DA's office in a very tricky position in terms of not being able to put together the witnesses necessary for a 20-year-old case. And in those situations, we have had to reach resolutions with the court. And when those resolutions are made, yes, Senator Morris, I am availed and aware of what is occurring. And I want to make it really clear, one of the biggest policy points is that there is robust victim and next of kin outreach in every single matter that is handled, whether it be on trials, whether it be on post-conviction.
Okay. So you look at all of them when they come through, and you contest some request for post-conviction relief. How many hearings have you had where you oppose post-conviction relief this year? Have you had any whereby there was an actual contested hearing, evidence produced for a request for post-conviction relief?
Let me answer that question a couple different ways. So, not a couple different ways, but on a couple different points. So, if you listen to the statements of Ms. Canizero Rodriguez.
Aside from that, I just want you to answer my question.
Give me the question again.
Have you had any contested cases this year in which there was a hearing over whether or not post-conviction relief should be granted, whereby you were defending the conviction, the defendant was asserting its entitlement to post-conviction relief, and there was a court hearing? Have you had any?
Yes, Mr.
this
Chair.
year?
Yes, Mr. Chair.
And how many?
State versus Wilbert Johnson. Since April of 2024, there have been 38 summary objections to post-conviction relief, beginning with State versus Wilbert Johnson. There are also cases.
You filed objections, but there haven't been hearings on them yet.
Still open. Cases still open. We're still fighting them.
Okay.
And there have been others where there have been hearings, and there have been others that we have fought and won, and there have been others where new trials were granted, and we tried those cases. I think it's important to note the Will Smith case, the case involving former Saints Will Smith, who was murdered. That case was overturned and had to be retried. It's very difficult to put together, so I tried it myself, and we got a conviction. The case of Evangelista Ramos himself, the pinnacle case that has been discussed in this courtroom, in this committee hearing, was a case that went up to the United States Supreme Court. I believed, and my office believed, that Evangelista Ramos was still guilty of the crime. We did not believe that that case was deserving of relief. and we retried that case before Judge Pittman in Section F.
Yeah, but nobody's accusing you of letting every single criminal go.
I thought I heard her say it, Judge.
No, but we're concerned about the number. But be that as it may, how does your office go about determining whether or not you're going to agree to post-conviction relief?
So let me see if I can explain it a different way. A lot of meat was left on the bone based on that last presentation. Once a post-conviction relief is filed with the court, the defense has an opportunity to present evidence. And
they file a motion.
Yeah, they file a motion.
But they don't present evidence unless there's a hearing, right?
But when there is a hearing, and there were multiple
But I'm asking
hearings.
about where there's no hearing because your office agreed to the relief.
So
how do you decide? How do you go about deciding whether or not you're going to agree to the relief?
So I'll give you one good example. Each case is different because there's no...
right, but you don't have a process? Like, this is what I have my staff do. Do they write a summary of the case? Do they provide them to you? Do they provide them to Ms. Maul, your civil rights directors? And do they analyze it? Do they go back and look at the transcript? Do they interview the attorney who allegedly didn't provide effective assistance?
All of the above. Everything you just described, Mr. Chair, is what is required in every single case. And what I'm talking about is...
So you go back, and if there's an allegation of ineffective assistance of counsel, you go back and you contact the attorney?
We contact every single person we can find, and we go through every bit of evidence we can go through. And I can show you how we've documented that because we've kept very good records of that. And I know that you've got some requests for documents, and I absolutely want you to get those documents because I want you to see what was said by the court, what was pled by the defense, and what our actions were. And I'll give you one example, just to kind of describe the process to you. Case of Jermaine Hudson. Jermaine Hudson was convicted by 9 unanimous jury of an armed robbery that happened in 1999. The victim said that he was robbed. He told his dad he was robbed on his way home from work. His dad called the police. Police came. He picked out Jermaine Hudson out of a lineup. Jermaine Hudson stood trial. Jermaine Hudson was convicted. As we were reviewing this post-conviction relief, Mr. Hudson... as we were reviewing this, after 22 years, the alleged victim called from a rehab center in Houma to tell us that he had lied, that he was never a victim of an armed robbery. He didn't want to explain to his dad that he bought some dope with the money, and he told his dad that. Jermaine Hudson was preparing to plead guilty to a lesser sentence to get home to meet his adult son, who he had not been in his life forever. And I found out in my first year that an individual was sitting in jail for a crime that had never even been committed. And let me say this, that was not because of prosecutorial misconduct. I know the prosecutor that tried that case. I know him very well, and he did his job very well. He was lied to. The police were lied to. And so I was in a position where I was about to have a man plead guilty to a crime that never even occurred. It required us to get into the records, and the records didn't show it. It was this victim, alleged victim, who came forward and said that the crime never occurred. And I just need to tell you this one part. He said he tried to call the Orleans Parish District Attorney's Office before, and no one would listen. And when we asked him why he tried again this last time, he said he heard that there was a new DA that was actually looking at the old files, that was actually allowing hearings to be had and allowing judges to make a decision about whether or not somebody got a fair trial or not. Sorry it took so long, Senator.
Okay. Well, look, I'll just jump right in. I haven't had time to review a lot of these files because, quite honestly, we didn't get much information until very recently. But I just picked up one that I think maybe Ms. Rodriguez may have mentioned briefly. And this is the case of Matthew Miller. And so I looked through, and that we have the pleadings and whatnot. And the facts, as recited by the Fourth Circuit on appeal, says that on April 7th, 1989, 8:20, Lisa Miller, the victim's two young children, victim's roommate, Tammy Duplessis, I'm sure no relation, were in the upstairs apartment. Directly below them, watching television, were other friends. The defendant, Matthew Miller, had approached the apartment, began knocking and banging the door. He continued until the door gave way and then entered the apartment. The defendant began beating on the victim, and Ms. Duplessis yelled to Ms. Cordova out of the open window to call the police. Ms. Cordova to call the police twice, went to the upstairs apartment and found the defendant sitting on top of the victim in a straddle position, beating her. Ms. Cordova grabbed the defendant from behind and pulled him off the victim. The victim stood up, ran downstairs. The victim, once inside, locked the door. The defendant went to the kitchen, removed a knife, ran out of the apartment, knocking down Ms. Cordova, attempting to stop the defendant. He ran downstairs, located the victim on the floor of the back bedroom, and began stabbing her in the chest with the knife, resulting in her death. Now, in response to the post-conviction relief requested goes like this. Although they were, now this is the defendant's attorney saying this stuff. Although they were very much in love, Matthew and Lisa's relationship was not a healthy one, which that's ridiculous. They were in love. The day after they got married, Lisa kicked Matthew so hard they had to spend several days in the hospital because she had ruptured his testicle. Lisa's behavior could be unpredictable and aggressive. She often initiated fights. As Matthew's brother Charlie recalls, Matthew would come to my house and he and Lisa were fighting to avoid altercations. Lisa would start fights over little things. It was this, she was looking for something to argue about. Clearly, victim blaming right here in a domestic violence situation. So, in response, your office says the state hereby affirmatively weighs all procedural defenses it may have to claim in the case. Your office concedes in their pleading that the victim they have expressed opposition to a reduction in the sentence on their own behalf and on behalf of their father, who is healthy but elderly. They are planning to attend future hearings in this matter. And in the face of this, their claim was ineffective assistance of counsel. And looking through your response, your office's response, I think it might be, let's see who signed the pleadings here. The only thing that is said in the response about the argument of ineffective assistance of counsel was that they claim there's ineffective assistance of counsel without going into any detail of why that was the case. This case raises arguably legitimate constitutional concerns about Mr. Miller's conviction and adequacy of legal representation provided him on direct appeal. The state agrees that there are potentially meritorious constitutional grounds for relief. You don't say what they are. You just say, we're just saying that it was ineffective assistance of counsel. And then you agree to the relief, and the order is stuck in front of the judge, and he signs it. Now, does this concern you at all, that the victim was against it, that you did not, despite what you say as having a very detailed investigation for each post-conviction relief, not one detail about why the relief was being granted other than ineffective assistance of counsel? I mean, I probably could have made up something. Do you have the concern that that person who brutally murdered his ex-wife being set free?
Yes, sir. Yes, sir. Look,
So,
let me-
so why would you engage in this to let somebody like that be set free without any articulable justification for it?
Well, I don't agree with that.
Well, it's right here in black and white. I mean,
They're more. Tell me when I can go.
you didn't put any. If there's more to it, you didn't put it in any of your pleadings. Or in this particular case.
And Senator, you know, we talked about Jermaine Hudson, which is a case of a person who was not just innocent of the crime. There was no crime. In some situations, when there's a hearing and evidence is presented, it shows that there was either cutting of corners, violation of constitutional rights, violation of due process rights, or cheating by the prosecutor. That can happen to an innocent person, and that can happen to a guilty person. In this particular case of Matthew Miller, defense filed a post-conviction application arguing not just ineffective assistance of counsel, but they also raised Brady claims for improperly withholding evidence. They raised NAPU claims, as well as that ineffective assistance claim.
What exculpatory evidence was there that was not provided?
Well, I don't believe. See, this is where
I mean, you just said Brady. I didn't see it in here, but it doesn't mention what exculpatory evidence was withheld.
Just let me answer.
Sure.
I said the defense filed Brady, NAPU, and ineffective assistance claims. That doesn't mean I agree with what the defense filed.
Your pleading says you agree with it.
The pleading says that we agree with the ineffective of assistance claim, not the Brady and the NAPU claim, which would have exposed my office to a lawsuit had that been granted. Had a motion for new trial and a post-conviction been granted based upon Brady and NAPU, now my office would be exposed. So by reaching a resolution where we maintain that conviction, we are not exposed. And yes, there was opposition to the resolution by the victim. And yes, we were in deep communication with them. And we read the victim impact statement from the family on the record to the judge in an effort to make the claim. I'm not suggesting Matthew Miller was an innocent man. I don't think he was an innocent man. And we were trying to protect the conviction in the face of losing it because of Brady and NAPU claims that had been filed. I'm not saying I believed in the Brady claims.
Okay. I feel like that's a stretch, but anyway, I need to go into some questions. I got Senator Clout.
Thank you. And thank you, Mr. D.A. Williams, for being willing to be here today. And I want to, on a good note, thank you for working with the Attorney General, the administration, the state police, and all the things that you are doing to make New Orleans a safer place. I think the governor at one point said, as New Orleans goes, Louisiana goes. And so we all have a vested interest in your work. I want to say a few things and ask a couple of questions. I know we're short on time. I think the first thing I want to say, and if you just let me run through it all, and then we'll go back and address what needs to be. But yes, on your statistics for the highest exoneration, I guess I really would like to see the statistics. I want to know, when you were saying that, how that data is where it's coming from, what it's derived from. And the actual data itself, if that could be provided.
Mike is making notes, and I'll make sure we get that to the whole committee.
Okay, be provided to us. And then, on a personal note, I don't believe that everyone should be locked up. I think that people make mistakes, and some people make very bad mistakes. And I don't believe I'm not a lock everybody up kind of lady, but I do think that there has to be consequences for bad behavior, especially when it's multiple times of bad behavior. It's just, society demands it. And I certainly, after working for 5 years now in the criminal justice system and walking the halls with a lot of inmates and on death row with inmates, I would hate to know that today there sits an innocent person still. So just there's that. And then I do want to say I have a few DAs from my district. I have 5 district attorneys in my Senate district, and they're all very great men, and they do very great work. One sitting right behind you, and Charlie's Riddle sitting a few rows back. And I have not ever heard or seen such cases. I haven't. No disrespect of people being let out after such egregious crimes. I haven't seen that in my district in the 5 years that I've worked with them. So this is all very new to me, and I want to understand why. I also have been learning a lot about the parole board and the process by which people do get parole. And I guess kind of pivoting off of what Senator Morris said, there's a mechanism and a really stringent review to make sure that those individuals, though they've committed some very egregious crimes, are ready for reentry into society. And we want to be, at the very least, if this is the process that we're going to, within our law, that we're going to put our stamp of approval behind as a legislature, we want to be confident in your process. We want to be confident in the parole board's process. And we have to have that demonstrated. We deserve that to be demonstrated to us. And I think you would agree, if you were sitting in this seat, you would want the process and the sanctity and, I guess, methodical nature of it and, serious scrutiny to be demonstrated and protected. So just speaking to what I do know about the parole board, and was supposed to go last week to watch one of their hearings, and I plan to go sit through it. But I know that they go through review of reintegration plans, resilience, work plans. They look at the support that they're going to have for family and community upon reentry. They speak with law enforcement, those that are in the facilities with the offender, like the warden and others that have had one-on-one experience with them. They look at their behavior and whether they have many marks against them and how long ago those marks were on that individual. They look at whether they're taking accountability for their actions and whether remorse is being demonstrated. This is all kind of in a rubric, and they're checking boxes and really going through a cross-examination for hours, days, maybe months and years in some cases with these individuals. They look at risk assessment scores. They look at the age of the offender and the time served. And they look at participation in certain programs, because we know that there are certain programs that offenders go through that help them kind of reset their thinking, and they weigh and measure their participation, their behavior, again, while they were incarcerated. So these are all things that they go through, they document, and it becomes part of the record on their decision. And so can you provide on these cases where we've seen some very egregious crimes committed and the release of those individuals, can you provide the documentation just like we expect of the parole board? These such things and maybe more, and to provide that to us. If you're truly going to counter and have people here at the table to counter with the documentation to prove that you've done a thorough review, and so maybe provide that to us.
Mike Hance, will you make sure that Senator Cloud and the rest of the committee have all that documentation? And it may not be in the brief itself, because there's not really a place for what that reentry program or intervention would look like. But we have engaged in exactly what you've described, and we will share that information with you in terms of where they are now, where they went when they first came out, whether we fought it and lost it, or whether it's one that we resolved. So we will absolutely share that documentation with you, because we have it.
Could you?
Because we're, I'm not cutting you off.
Okay.
I'm not cutting you off.
Okay.
But since we're on this topic, just to kill two birds with one stone, so to speak, I'm going to introduce this letter into the record in which I've asked, that you've already received, asking for documents. Mr. Browning alerted me that you wanted 90 days. Rather than by the end of this month that I had requested. 90 days is just too long, but I would like to get your agreement to provide the documents requested in this letter within 45 days till the middle of October. That's
A month may be enough time. There are certain requests that I think make it a little bit difficult, but 45 days. I mean, we're going to do our best to get you. Everything is on the record. We're going to provide everything that we have access to to you. Just like we dropped off a bunch of binders to the AG.
Right.
We have nothing to hide. We want you to see what we like. My son. When he's doing math homework, teacher wants to see how you got to the answer, and I want to be able to provide that to you.
Okay. Well, I'm gonna. I think the record's clear. You have received this letter. I'm gonna introduce this into the record. So I'm sorry to interrupt you, but since we were on the subject of documents, I thought I'd get that out of the way.
That's perfect. And I think I wanted to just make the point that, in saying what I'm saying, in comparing the process of the parole board, I do realize you don't have the same discretion and authority of the parole board. But I think my comments are more that you're taking time and a methodical nature to bring in all the stakeholders that have a rapport and history with the offender before you're making decisions. I mean, imagine being one of us, seeing all of those things and hearing all of those things. I'm not concerned with past administrations or the politics or any of those things. I'm concerned about what I saw.
And look, I saw Senator Morris when I was getting coffee this morning, and look, you all are good people who are trying to do the best for the state. And so the fact that you want to have a conversation about this very complicated thing that the AG did a really good job of showing how it works, I think it's a good thing that we're having this type of dialogue. And the fact that and I'm going to get you those statistics so you can see how we have been presented to the country. And I'm not talking about Louisiana, I'm talking about New Orleans, Louisiana. I'm going to share that with you. But there's work to be done, and if there's a better way to do it, I am open to it. In the words of John Lewis, we might not have all come over on the same boat, but we're on the same ship together right now. And I look forward to improving my city because I know that's going to improve the state.
Thank you. Thank you for being here.
Okay, thank you, Senator Cloud. Senator Klein-Peter is next in the queue.
Thank you, Mr. Chairman. Thank you, Mr. Williams, for coming today. It is important. New Orleans is important to this whole state. I have a couple questions specific to some of the things that were brought up. The one that admitted to the murder, does your office plan on taking Mr.
Yes,
Green?
it's just not as quick as some folks might want it to be. I want it to work. I want it to stick, and I want to make a good case. But we are actively working on it.
Okay, and then
connection. Just since Senator Klein-Peter's on that, you didn't provide use and immunity to anybody in that case.
No, sir.
Okay.
No, sir. And we didn't bring him to court. That was the defense attorney who presented that witness to the judge, and the judge, as an officer of the court, heard it.
Okay, fair enough. Okay, thank you.
And
I'm sorry.
I don't know if you have the statistics, or maybe we can get it on the next, but has crime really gone down, or has the prosecution gone down? Specific, there's an Instagram, I'm sure you're aware of, Bayou Mama Bears.
Yes, sir.
And there's a post 2 days ago that I really am interested to hear your thoughts on this. Are you aware of DeAndre Hickman?
I was alerted to the post, but I was preparing for today. I didn't.
Okay.
I'm not done
All right.
yet.
He was arrested in 2023. DA refused charges in 10/10/23. He was arrested for strangling his girlfriend and stealing again in November of 23, and the DA refused charges in 12/1/2023. In May of 2024, arrested for beating up his girlfriend again, and the DA refused charges 6/18/2024. And here recently, on August 27th, arrested for armed robbery. That's my question is crime going down, or is the prosecution going down?
Crime's going down by all measurable standards, except for sexual assaults and sexual violence against women. Every single category that is measured nationally shows that the city of New Orleans has reduced crime in those categories more so than any other city per capita. And that's just data. That's not my numbers. I didn't come up with that. And with regards to that particular individual, I don't want to speak on an open case, but I will
understand.
tell you that domestic violence cases are extremely, extremely difficult to prove. I will never blame a victim or a survivor of any crime. Oftentimes, folks are willing to call the police, but they're not as willing to come to court and testify, and there are a multitude of reasons why that occurs. I've seen domestic violence in my own family, dating back years ago when I was 8 years old. My aunt finally left the man that had been beating on her for years, and he went to go retrieve her in Bogalusa and said she better come home, and then when she didn't come out of that door, he shot my two uncles in front of her. So I know how difficult it is to get out of those bad situations. It's the hardest cases we have to prosecute. They keep me up at night, and we're coming up with strategies to use body-worn camera footage so that we can prove those cases so that the partner or the woman doesn't have to testify. But we can just use that body-worn camera footage to show the injuries so that we can get dangerous people off the street.
Okay. I have no further questions. Thank you, Mr. Williams.
Thank you, Senator Klein-Peter. Senator Miguez.
Thank you so much, Mr. Chairman. DA Williams, thank you so much for joining us here today. A question about, we talked about policy earlier. Do you have a written policy on chain of command for major decisions like resentencing, plea deals, charging decisions?
It's got to come through me.
Okay, and what does that policy look like down from you?
Down from me.
Like, as in, how does that policy work for each one of your ADAs coming up to you? I know you.
Okay, I see what you're saying. So, for example, policy decision on the habitual offender law. When I came into office, we were not using the habitual offender law because, as you just heard from Senator Duplessis, my predecessor was using it almost in every single case, whether it was one joint or pill. And so we got the state paying for people who are addicts. That's not smart. That's not wise. It's better use of money. And so we then reintroduce the habitual offender law for violent offenders, either someone who was violent before or is violent now, right? And so we reintroduced it, and my lawyers have to write a quick memorandum to me why they want to use it in this particular case. Why is this guy so bad? And every single time that it's been requested, it's been granted. But we are making a record of it. We've got an agreement with the Tulane Law Clinic where they check our the use of the material witness warrants. Because we were sued for that because of some decisions by the last administration because people did not want to come testify. We have only had to issue one material witness warrant in my 3 years, but that process also has to come through myself or the first assistant. And we have to make a resolution, whether it's a resolution that turns my stomach or it's a resolution that I think is the right thing because the person is factually innocent, that has to come through me as well.
And you're involved at the last buck in every decision, right?
It's all on me. That's why I'm here.
Is that a consistent policy across each division?
Well, I will say that with regards to the trials divisions.
How does, in particular, the civil rights division work?
Comes through me.
Okay, comes through you, and that's consistent policy. What about your policy for the Civil Rights Division on screening cases, how they choose which cases to review, and what are your general aspects on that policy?
So when we were in the middle of, and I'm sure you all remember, the flux sort of area when the Supreme Court was deciding the Ramos case and the Edwards case, it wasn't clear exactly how everything was going to fall. I want to be briefed on every case that is going to be dealt with, but there are filings that have been made. There are requests for records by defense counsel. That's step number one, right? Because they don't have those records. Step number two is some defense attorney files a post-conviction with the court. The way it works in Orleans Parish, some of the courts will say to the defense, I'm giving you X number of days to respond to this filing. Some courts don't even let us know that there's been a filing, and we don't know about those. I can't tell you how many of those exist. We then respond to that, and then hearings are had.
Earlier in some of the earlier testimony, there was some statistics given about the 350 resentencing cases since you've been elected, as well as 42 cases just this last year. And they made some comparisons to local jurisdictions like Jefferson Parish, St. Tammany. I think even East Baton Rouge Parish gave some statistics which were gave us the impression that subsequent post-conviction relief isn't used very often as compared to your office. Can you give me, maybe a quick general explanation of why it's used so much in Orleans Parish?
When you look, so I remember I was elected maybe, I'd been in office maybe less than a month. And I was meeting with the DA of East Baton Rouge. And I had a bunch of questions because I just got the job. And we sat down and he was walking me through his process, and I took some forms and we sat down with his team and we worked together to sort of orient me with this work. And one of the first questions I asked him, I said, how many times y'all use a multiple bill? He knew every defendant's name, and he knew exactly how many it had been used. Whereas in Orleans Parish, when the person would come to court for arraignment, they would say his name, they would say his bill status, and they would say, we're going to bill him if he doesn't plead guilty. And so 2,700 compared to a handful means that we got a lot more people sitting in jail for chump amounts of dope or marijuana or low level, stealing an umbrella off a porch, stealing some hedge clippers, going to jail for double-digit years because habitual offender law was applied. So yes, we have intervened in some of those situations, and some of them, the lion's share of those don't involve any violence.
Your testimony would be the main reason would be your opinion, the excessive use of multiple bills in Orleans Parish compared to others.
We have been an outlier in terms of how many people we've been sending to prison and for what. It's very different compared to what other DAs have been doing.
So there's some other statistics, data that shows, and tell me if you disagree, that the 42 that were mentioned earlier, many of those happened over the summer in a very short term right before the new bill took effect on August 1st. Is there an explanation why so many resentencing in such a short amount of time and an increase of the statistical data there?
Yeah, I saw the tweets and that were put out saying that we were speeding up to this date. Number one, I wouldn't have done that to my partner behind me, the AG. She's been an amazing partner to the city of New Orleans in terms of figuring out ways to augment the DA's office and getting Colonel Hodges where he needs to be to help us reduce crime. We have a data sheet that I can share with you all that shows down to quarter two, quarter one, quarter two, quarter three of all the cases that we have resolved. And when you look at the number between 2021, 2022, 2023, 2024, there were more of these sorts of cases in 2021 and 2022. There were less in 2023 and less in 2024. There was no rush to do anything. These things are filed by the defense attorney. We are not initiating post-conviction relief. Post-conviction relief is initiated on the other side of the V. So we did not rush any cases.
If we look at the data in 2024, it won't show that there was some type of increased action on the district attorney's part to move these cases more quickly through the process to get a verdict from a judge and a subsequent outcome.
No, it won't show that there was any action by the defense by the state. It may show that defense attorneys were anxiously trying to get things filed because they knew something was going to change. But you can look at the records and see who filed what and when, and you won't see any action on the part of the state.
But the district attorney has a part in that process
Yes,
by whether you take an adversarial position or not. And the judge takes that into account, and it determines the outcome.
And we take an adversarial position in the lion's share of these things and have fought a number of these cases. That's not getting publicized.
Have you taken a non-adversarial position in an increased amount of cases prior to this becoming effective law during this summer in 2024? Have y'all taken a less adversarial position on more cases that were filed by defendants over the summer prior to this bill, this new piece of law coming into effect on August 1st?
No, sir. There was no change in pace.
And I have to, in the fairness, I have to give you the opportunity to speak for yourself. We talked a lot about the definition of public safety. Senator Plessis brought that up as a priority in Orleans Parish. And there is some differences, and you've explained your explanation as to why there's a difference in statistics and numbers. But what is your definition of increasing public safety, and what do you believe your mission is as a district attorney?
Same mission that you heard from Hill and Moore's assistant. A prosecutor is a minister of justice, and justice has to be applied equally under the law for everyone. Public safety is the primary goal.
Does that include keeping violent criminals who have been prosecuted and have exhausted their appeals in jail so they don't re-offend and hurt innocent people in Orleans Parish?
Absolutely.
Is that your number one priority?
Public safety is my number one priority.
But in order to achieve public safety, wouldn't you believe that keeping violent criminals locked up is one of your number one priorities?
Absolutely. However,
if they committed the crime.
Yeah, absolutely. However, I must say that once there's been a showing to a court that a conviction was defective, either because someone cheated or withheld evidence, whether that person is guilty or whether that person is innocent, that is not something that I can, as an officer of the court, sweep under the rug or ignore, nor would any of the 12 judges at Tulane and Broad ignore if they saw a prosecutor withheld evidence in a case of a guilty man. Do you follow what I'm saying there? So it's not just enough.
You have to balance constitutional rights, but first of all, if they have committed a violent crime like beating a child, 2-year-old child with a belt to death, raping a female. You mentioned that the domestic violence against females is increasing in the city of Orleans, and you believe in your heart they actually did that crime. Don't you believe it's your task with the duty to keep those people off the street from hurting other individuals? I mean, when they commit that crime, they have torn the fabric of society. And the only thing that stands between them and innocent victims in the future is our district attorney.
Senator Miguez, you're absolutely right. In the case of Mr. Matthews, that matter was, there was a presentation in court, and we fought it. We fought relief in that case. We objected to it. The words and quotes that Laura Canizero Rodriguez showed to you were the defense's words, not the state's words, right? And so when my trials division is saying that the judicial clemency that was granted to Mr. Matthews was illegal, that is right, and that is the same argument we made to Judge Roche. And if in fact he does not grant our motion to reconsider his ruling, we are going to figure out a way to try that case because I believe that he should remain behind.
Let's be clear here, though. But your attorneys waived time limits.
My attorneys allowed the case to be heard by the court.
Your office took inconsistent positions with this case.
No.
Why would you waive the time limits?
We waive the procedural bars so that a judge could have a hearing and the case can be heard. And at that
why would you do that, though? If you believed he was guilty and should stay in prison, why would you waive procedural articles?
I see what you're saying.
Why would you do that?
I'm going to answer, Mr. Chairman.
Okay.
You can't look at the side of a banker's box and figure out everything that has occurred in that case. And if there were violations, and look, and just like Senator Miguez was just asking me, we all believe in the Constitution, but we can't believe in the Constitution a little bit. You can't be a little bit pregnant. You can't cheat some of the time. And so what I'm saying is...
You're diverting my question.
I'm coming right back to it. And what I'm telling you is the position of the office...
And you're good at it, by the way.
The position of the office was to allow a hearing to be had. At that hearing, we fought it because we thought that the evidence was in our favor and he should not be granted relief.
You could have just ended it by not agreeing to waive the time objections. It could be over.
I could have done that on all these cases.
Right.
Jermaine Hudson still be in jail.
Yeah, but why wouldn't you do that?
Because in my first year in office, a man was about to plead guilty to a crime that never occurred. And in the city of New Orleans, we have been so good at mass producing defective convictions that I think it is incumbent that we make sure that we let cases be heard and that the right...
You could have ended this by not signing that waiver, and you did it, and now you're faced with having to retry the guy. But be that as it may, those inconsistencies, and I'm sorry to have interrupted you, but I just want to clarify what we're talking about here.
Senator Duplessis had in an earlier question and had mentioned that the voters of Orleans Parish, by overwhelming vote, had voted for a new direction. And it sounded like a philosophical difference that he was describing in Orleans Parish compared to the rest of the state as it relates to your office in criminal prosecution, Can you give us more details on exactly what he was talking about? And I know your office is unique.
Yeah.
Tell me exactly what he meant by that.
Well, I can't tell you exactly what he meant. I
Well,
know he
what-
can take it.
Well,
I'll give you my
yes, your
position.
you were on the ballot, so I mean, I'm gonna let you speak for it. You get the information straight from the primary source.
I understand why the last presenter will probably spit on my grave whenever that day comes. I get it. Her and her dad and I went back and forth on a lot of different things. Right? That's fine.
Yeah, and those are personal deals, but
Yeah,
but just before you can finish that, she did offer a lot of evidence, if true, which could be compelling for this legislature to look further into these matters and to look at potential oversight for district attorneys across this state. Because it's very disturbing that one case when you get a 2-year-old that's beat with a belt, or a woman that's murdered, or someone who kills multiple people. Those are very, very disturbing things. And I don't think that's acceptable in any parish across this state, including Orleans Parish. And if they're true, we have a real problem with that. And I don't want to make it just personal because she's made some allegations. She's backed up with facts. And
She backed it with pleadings. A lot of it in the words of the pleadings that Mr. Williams' office filed. She didn't make it up.
And I think you'll have an opportunity to come back before us and hopefully present and whether refute or agree, whatever your position is in each one of these cases. But let's not make it personal so much against her because we're not worried about your personal dispute with her or the former district attorney and you.
I don't have a dispute with her.
We're not worried about who's spitting on whose graves here. We're worried about the public safety for the people of Louisiana and specifically the people of Orleans Parish, and I want to keep the conversation to that point. But if you have a philosophical difference versus other district attorneys across this great state, I want to know about them.
I don't. I just believe that the city of New Orleans has not. When you look at your prosecutors in your home, jurors believe in them. They believe that they care about getting it right. They believe that other DAs for decades have worked to get it right. And the jury believes in the system. In the city of New Orleans, we were sued a few years ago for issuing bogus subpoenas to make people come and testify. Innocent people. I'm not talking about someone who's in the system. Innocent people were forced to come, and we were sued because of that, because people just simply did not believe that the system was fair and equal for everyone. And I'm working really, really hard to build that trust because we can't do it without witnesses coming to court. And the one thing I'll tell you, I didn't bring that up to make it personal. I brought it up because there should never be a double standard at all. And in the case of State versus Bobby Jean Johnson, a decision was made to reach a resolution. And my predecessor said, we are satisfied with the result in that we finally got a woman who killed a teenager to acknowledge and accept responsibility for her crime 41 years later. That was the exact same type of resolution that we're talking about today. State versus Michael Thomas, John Thomas, and Stanley Thomas. This is a case in which the DA intervened, the previous DA intervened, and reached a resolution on a post-conviction relief. State versus Michael Williams, Gerald LaBeouf, Louis Alexander. State versus Trinidad East. State versus Albert Wolf. State versus Benedict Cately. These are cases in which the previous DA did the exact same thing that I've done. The only difference is mine was on the record, and we put it in briefs while we made these decisions. In the case of State versus Darnell McNeil, Lon Washington, this is a case in which the previous DA reached a resolution in a case in which Bayou Mama Bears tweeted that we did something wrong when her father did the same thing for a co-defendant.
Let's back up. All post-conviction relief has to be on the record, no matter what. It can't be not on the record, right?
We have made more of a record than any past administration of any post-conviction.
Sometimes the defense attorney and your civil rights attorney go into court, and it's not it's not on the docket, and they announce that they have reached an agreement, and then they hand the order to the judge, and it's done.
Well, I really would like for you to come to Tulane and Broad and see the process, because what's been told to you is
I'm aware.
not how it plays.
I'm aware. Admittedly, I go to the building on Loyola a lot more, but I'll come to yours as well.
I really want you to come.
You know, and you have repeatedly said you're trying to right the wrongs of the past, but not one of these cases that we've reviewed was somebody factually innocent. And that can't be lost on this committee, that these were guilty people, many heinous crimes. And you spoke of domestic violence. These, I just flipping through them, I saw 4 or 5 that were domestic violence to the nth degree. It was domestic murder. And your office agreed to let these people go, and that's why we're concerned about it. And the stated reasons that are in these documents that I've seen are pretty tenuous. But be that as it may, I'm going to let Senator Miguez finish up.
Can I briefly?
Yes, you may.
I do it in 30 seconds.
Of course.
And I believe you're a title attorney by trade. Is that right?
Mortgage, real estate, et cetera.
And you know, whether you buy a house that's worth $100,000 or a house that's worth $7 million, you want clear title. And some of these convictions that have occurred in the city of New Orleans, where the person's innocent or guilty as heck, don't have clear title.
Well, and if you want to use that analogy, you're not entitled to a perfect title. You're entitled to merchantable title. And you're not entitled to a perfect trial either. And so trials aren't perfect. They're messy. I know that. I'm not a criminal lawyer, but I have tried a criminal case or two in my day. And I've tried some civil cases. And I've tried some jury cases. And they're messy affairs.
Yes, sir.
And they're rarely perfect.
Yes, sir.
But when we have somebody factually guilty, to go in and do this is very concerning. But in any event, I'm sorry, Senator Miguez.
Well, not a problem.
I digress.
I enjoy to have you involved in the conversation, Mr. Chairman. District Attorney Williams, in some of your open statements and some of the statements from Senator Duplessis, one would believe, if you haven't never visited Orleans or read the newspaper, that it's a safe place to go and things are great there and crime's going down. You don't acknowledge that there's some serious problems still with crime in the city?
Oh, absolutely. No, look, I don't think the senator was waving a victory flag. I wasn't waving a victory flag.
Just want to make sure that's the case. There's still a lot of work to be done there.
A lot of work to be done, which is why I don't want to derail the relationship that we built on the state level, because we're in 2023, working with Chief Michelle Woodfork, we have brought crime down from where it was before, and we can't ignore that.
And I want to talk about that relationship a little bit as well.
We want to keep it going down. We want to keep it going down. And these relationships are important.
To my knowledge, as you correct me if I'm wrong, I don't think there's any other district attorney that has the type of assistance from the Attorney General in prosecuting crimes. I don't think there's any other parish across the state where we have entire state police going there appropriating money to investigate crimes. That doesn't concern you somewhat that you need assistance from the state to resolve the issues? I mean, that just tells me alone there that there are severe issues, not just small issues. If the state has to appropriate it, look, I'm not saying I don't disagree with what the governor's doing and the Attorney General. There's got to be some severe issues there that need to be acknowledged. And you have to be open to the oversight. If we were spending tens of millions, $100 million there, and we had to send state police, our own police force, and we got to get the Attorney General to prosecute the crimes. I mean, at this point, will you turn this Orleans parish around and all your locals, or should the state just run the parish for you? Do you think we'll get it back?
Well, you know, Senator Miguez, I'm here voluntarily.
Yeah.
I came because I wanted to have this conversation. Just like Senator Cloud was saying, I'm not going to claim that Orleans Parish is perfect. We got warts and moles out the wazoo. But I'm also not going to ignore the successes and gains that my office achieved at the worst possible time. At the worst possible time. And I'm also not going to pretend that the city of New Orleans is not sending a great amount of revenue to the state.
Absolutely.
And the fact that the governor and the AG believe that helping a parish in the middle of a crisis help it achieve more public safety gains, I think that's a good thing, because another parish is going to be in the exact same boat, because that's just the way the world works.
But the fact remains that constituents in my district, and as well as many of the people on this panel, don't feel safe going to Orleans unless they got a large caliber pistol, 2 spare magazines, and wearing a bulletproof vest. And we got to get the situation fixed.
Well, I can tell you there's not a single prosecutor in this country who's tried as many murder cases personally in court and gotten convictions in this country. I am in court with my young prosecutors, teaching them how to try the toughest cases, teaching them to try rape cases, serial rape cases, and I'm going to keep doing it. But we're working really hard to fix our own problems. We appreciate any other assistance that comes to bear. But a big part of being able to prove a case in court is having a jury pool and 12 members of that jury believe in the office. And we have been building that trust. And part of building that trust is what we have done in the Civil Rights Division. And the chairman's right. It's messy. There are some gray areas. But I would invite all of you to come and watch the process to understand that we're just trying to make a fair system, to make sure that everybody, because in Orleans Parish, you might have one family that has a victim in January and a defendant in August. This is very tight quarters. It is very close quarters, and people need to believe that the system is going to treat everybody fairly when they come through it. And just looking back in cases when there is defective title, I'm not saying perfect title, but defective title, making sure that a court of law and the DA will not ignore it, regardless of guilt or innocence, but let the court make a decision. I think it's the right thing to do. But look, I am open and willing to work with this body and any other body to discuss making sure.
And we appreciate that.
Yes, sir.
As this process plays out and we get to the bottom of the facts and we have further hearings, do you think other district attorneys across this state will sit next to you and approve of the decisions that you have made in the past on subsequent post-conviction relief? Do you think they support you, your colleagues, and your peer group?
I think that.
Or will you be standing alone defending yourself?
Like I said before, when you asked me what Senator Duplessis was thinking, I can't tell you what another man is thinking or another woman is thinking. What I can tell you is that the district attorneys in this state have discretion to deliver on their commitments and the mission, and it's the same mission. And public safety is the ultimate goal. And that discretion is very important because each judicial district is very different. Each judicial district has very different needs. Each judicial district has a very different history with the criminal justice system.
And you do also recognize that the decisions that you're making and the actions in Orleans Parish is bringing them under a microscope as well, and the legislature considering things that haven't been discussed in great detail in the past about potential oversight over district attorneys in this state.
That keeps me up at night.
Very similar to and that happens in other states across this nation.
I've watched what's happened in other states across this country. Because and I would hate for people to come to New Orleans for the Super Bowl and see the city of New Orleans and the state of Louisiana waging some kind of war.
It's not a war. I use your own words of trust. Not only do you have to earn the trust of the people of Orleans Parish, but you have to earn the trust of the other constituents across the other parishes across this great state, because Orleans is such an asset to the state, and we want to make sure it's successful. But remember, the actions of your office and all the people underneath you affect the rest of the district attorneys in this room, who this legislature supports. We want to make sure they do a great job, but we'll have more hearings and we'll get more details. And I just want to make sure, on the record, whatever the chairman submitted to you in that letter, I don't know the exact details, but I want to make sure that you can come forth in the future and address each specific case that Ms. Rodriguez had brought forward, or any other cases that she provides to this committee as well, because we want to hear about the specifics to let some of the attorneys get involved in that and get a specific explanation, because there's some very appalling accusations or cases that were brought forward today.
Yeah, and and I appreciate you keeping that phrase in there. What Ms. Canizero Rodriguez said, if true. I remember you said that. And I look forward to you all being able to look at the complete record and make your own decision.
Thank you so much for your testimony here today.
Thank you. Before I get to Senator Duplessis, I got a couple of things I want to go over. First of all, in response to Senator Miguez's question, do you have a different philosophy from the other DAs? And you said no, or absolutely not. I can't remember exactly. I would challenge you on that because you ran for office on a progressive platform. Did you not?
Look, I said that the criminal legal system needs to be as smart on crime as it is tough on crime.
Right. So you ran on a philosophy that's different from a lot of other DAs. You said that you wouldn't enforce, for example, if there was a abortion law crime.
Is that why we're here?
And you said you wouldn't. No, but you said you didn't differ philosophically, and I'm saying that I'm challenging you on that, and that's just an example. You ran on a philosophy that's quite different from the majority of the DAs in the state, right or wrong. So I think that can't go unnoticed because, as you'll notice from the legislature, we have probably what would not be considered a progressive philosophy as a whole. So, everybody's different. Senator DuPlessis and I don't always agree. Every now and then we do. So I think that's something that we're going to be thinking about. Now, another thing I wanted to ask you about is I asked about your internal policies that you have with respect to post-conviction relief matters. Do you also have policies in your office regarding conflicts of interest? Because a lot of your assistant DAs and you as well were formerly defense lawyers. And of the 36 to 40 cases that we reviewed, you and some of your assistants were defense lawyers on some of those cases. So do you have a policy, written policy, in your office to address that?
Yes, sir. Okay. If there's an instance in which there is a conflict of interest as defined by law, we have referred that case to the Attorney General. In fact, there's an email, Tim, if we can share it with this group. There was one case in particular that I think was brought up, the case of Jared Crowther. There's a case in Section J. Can you hand that to pass that to the committee? As a case in Section J involving an individual that was previously represented by someone who was an associate in my office. Mm-hmm. The judge in Section J recused the DA's office because that lawyer had previously been working in my office. In court, the judge said that he was going to appoint the Attorney General. The judge didn't do it. The judge did not appoint the Attorney General. And at a later date appointed the Loyola Law Clinic. This email is an email that my office sent to the Attorney General's office, making them aware of what occurred in that particular case.
In some instances, when there appears to be a conflict, you obtain the appointment of a quote-unquote special prosecutor, as I recall, from some of these cases. Have you ever done that? Was a Ron Wilson ever appointed as a special prosecutor in any of these cases?
What case are you referring to? I just don't have that in front of me.
Let's see if I've got it here.
I don't believe that I've ever appointed a special prosecutor.
You've never gotten a special prosecutor appointed?
The only case that I'm aware of that is currently being dealt with right now under my administration would be that case in Section.
I don't have it in front of me, but that'll probably be the subject of a subsequent hearing. But regardless, you do have written internal policies, and of course we requested it in our letter, so we hope to see that in 45 days, which I would say let's make it October 15th, just kind of right in the middle of the month, which.
Yes, and I think it's under the law, if I could just make clear, I mean, DAs and prosecutors, we don't appoint. That's not how that works. That would have been the court.
Yeah, it would have been the court. Okay, fair enough. Okay, on to Senator DuPlessis. hang on, Senator Miguez has a point of order. Let's see.
Just real quick, Mr. Chairman, I was reading through your letter about the requested information. If you happen to decide to have a subsequent hearing, could we get the whoever's in charge of the Civil Rights Division here with the district attorney next time?
We can request, and if, need be, we could
Subpoena.
Subpoena.
We're going to get him here. Okay, I appreciate it. I think that would be very helpful.
I did request Ms. Mall's attendance today, and I didn't hear back from her. But be that as it may, I wasn't going to push the issue just yet.
Make it clear, I thought it best and prudent. As I said before, everything stops with me. The buck stops with me. I am responsible for what happens in the Orleans Parish District Attorney's Office. And so the idea,
Mr. Williams, but if we have a subsequent hearing, we're going to probably be digging down a little bit deeper into the details, and I think it would be beneficial that both of y'all were here to help us provide the adequate information, if that's okay with you.
like I said, I'm here voluntarily. I mean, this is. I've got.
Does that mean that
I've got cases I've got to try?
She works for you, so does that mean we can get her to testify?
I just want to make it clear
this?
the buck stops with me. I am responsible for what happens in this office.
Yes.
I think he's looking for a yes or no.
I know that.
So the question is, will you ask her to come voluntarily, or do we need to subpoena her?
I mean, it all depends on when we do it. If we're going to be doing this every week, then
the chairman's got to handle that.
There's no definitive plan, but what we need first is all the documents.
Yes.
That getting them from the clerk of court was very difficult, and your office provided some to Ms. Merle, and that was, I understand, and the documents provided to Ms. Merle were very helpful. So once we get those, we're going to review those, and we have some prosecutors and people who are going to help with that.
Yeah, and I'm sure the chairman's going to work on scheduling,
and so it'll be we'll have to get the documents, then we'll have to analyze them, then we'll have to have another hearing. So I don't anticipate one anytime soon. So no, we won't be here on a weekly basis.
He did that, Mr. Chairman. He did that sidestep thing again. He didn't tell me whether she was going to show up at this committee.
We don't have a date yet.
Well, once we have a date, maybe we'll get an answer to that question.
I mean, I'm glad we're talking about this. Let's keep talking about it.
Do you have any reservations with her speaking in front of the legislature?
No, I mean, I had reservations about coming because I didn't quite know how I was going to go. I mean, you didn't. I don't spend a lot of time at the Capitol. I spend a lot of time in court.
I understand that.
I'm on different ground right now.
Okay, I think you understand where we're going.
I'm more than willing to provide all of our documents and provide all of our information.
And employees.
And I'm here voluntarily because I'm glad we're talking about this.
And employees.
Well, I don't think we're going to get an answer on that, Senator Miguez.
I'll start researching the subpoena process if it's necessary, if I can't get a straight answer.
At some point, we'll have to cross that bridge, and hopefully we won't have to fight our way across it, but we'll see. Now on to Senator Duplessis.
Thank you, Mr. Chairman. And DA Williams, I just want to thank you and your staff for being here. This is a lot of time and resources being dedicated to an hours-long hearing when we have big issues in the city of New Orleans that we need to be tackling. So I just want to thank you for your willingness to come here today, your cooperation, and your service in a very difficult role, which is trying to stop crime in the city of New Orleans, to try to make New Orleans a safer place. We can dispute whether or not we should be celebrating the significant reductions in crime or whether we should be focusing on the lack thereof. The more that we have to do, we can go back and forth on that. But the fact of the matter is, violent crime in particular, has been significantly reduced. And I think for a lot of different reasons. And I would like to take this opportunity for you to talk a little bit about some of the other programs that I know that your office has instituted outside of just post-conviction decisions, like the No Dice program and other things that this office is doing, because this hearing has seemed to morph into something other than a conversation around post-conviction. And I think I see where it's going, but I'd like to just give you that opportunity to talk briefly about some of the other work that your office is doing, in addition to what I think is an unprecedented move to voluntarily work with the AG's office, to voluntarily work with state police, to voluntarily work with the governor's office to welcome support to the city of New Orleans to deal with the issue. So can you talk a little bit about some of the other work that your office is doing?
Absolutely. So it's absolutely the hardest job I've ever had in my life. And I want to say that you talk about these other DAs around the state. These guys these women and men work very, very hard to try to make their jurisdiction safe. And it is a difficult task. And in the city of New Orleans, we have more incidences of crime. And in response to that, we have partnered with a group called Bancroft Global that includes former FBI agents, CIA agents, and NSA agents, using the same techniques they used to go after Osama bin Laden, figure out where he was. We have brought them in to help us use social media to solve crime so that we're not just arresting the shooter, but we can actually get to the driver and any accomplice and anybody else that was involved in those cases. And that work is yielding very solid results in court. It's gaining national attention. We brought in Chief Michelle Woodfork, who is learning this work from these NSA and FBI guys, and the relationship between myself and the NOPD homicide detectives has never been better. It's bringing crime down because we're actually solving it faster, and so we've got a faster solve rate. On the flip side of that, I've got Daniel Shanks and Andre Godin, who have helped stood up the No Dice program, which is working collaboration with every department at City Hall, the City Council, and we've shut down problematic corner stores that were selling drugs and guns right outside of the French Quarter. One police officer stopped by and said he'd been complaining about that building since 1981 when he was on the force. He's retired now. We shut down the tire shop on Claiborne Corridor where there have been murders and rapes and drug dealings. And Councilmember Eugene Green said that the Baptist minister around the corner had started back having Bible study after we were able to shut that place down. And we were able to have the city come in and put up street lights in that area as well to make it safer for those children who have to cross that intersection to get to school. The No Dice program just yesterday announced the closure of the London Lodge Motel, where a 3-year-old had been shot through a wall, where a rape had occurred, where a murder had occurred. And that is working in communities, figuring out those places that are the hubs of violent crime so that we can root that out. And that has been a game changer. And so, yeah, we're working really hard with the Civil Rights Division to deal with defective convictions in situations where things weren't done right before. Sometimes it affects an innocent person, sometimes it affects a guilty person. And it is deeply painful and traumatic to go through. And we have reached out to victims every step of the way to let them know what's going on. And in one instance, in the Darnell McNeil case, the family wasn't aware that the last administration had reached a resolution. They were only aware because we had reached out to them to talk about this last case.
But in some instances, the victims complained and didn't want somebody released, and you agreed to release them anyway.
And we represented the victims' words on the court and read the victim impact statement.
Otherwise, we wouldn't know that.
No, my office.
I understand, but we as a committee would not know that if it wasn't on the record.
Oh, but I would have shared that with you. I'm not going to hide anything. I'm not going to hide anything because I want you to be able to see which ones we fought, which ones resolutions had to be made on. But to answer your specifically, we are engaging in partnerships that you've never seen before. And the work with the governor and the AG on electronic monitoring, which has been a problem from everywhere from West Feliciana and to Orleans Parish. The AG and the governor brought in the Supreme Court. They brought in senators and representatives and OJJ to help us deal with the problem of electronic monitors in the parish of Orleans. And I truly believe we're going to come out of it with a better system of accountability for young people. And, you know, that type of collaboration, I don't think existed.
I agree. When Act 10 was introduced and passed during the special crime session, did your office take any public opposition to that? Did you oppose that law in any way?
We did not. We will follow whatever the law is.
Right.
If the law changes, we'll follow that law. That is not the role of a prosecutor to create new law. And I agree with the AG when she said that. It's not my job to disagree and do something else.
Right. So
there may be disagreements about the process and the resolution, but following the law, we did it. Abiding by the law, we will continue to do it.
And just my final question, it kind of goes back to the question of philosophy, and that's been brought up a couple of different times, the creation of the Civil Rights Office itself, and your belief that there was a need to do that. I think a lot of times, particularly in this building, because Chairman Morris represented that this is an overwhelmingly conservative legislature, right? And we're talking about it in the context of public safety, as though the people from New Orleans don't care about public safety. What I want you to do is just speak a little bit about why justice, from the standpoint of the Civil Rights Division that you created, is so important for the sake of trying to achieve public safety, because those two things are not, they're not two separate ideas. How do we use the resources and the effort you've put into trying to correct injustice for the purpose of making New Orleans a safer place?
So as part of our effort to win cases in court, part of that effort required building trust that did not exist. And in an effort to build trust in the criminal system, we have used our discretion, always within the guardrails of the law, to allow courts to look at the fairness and constitutionality of past convictions and sentences. And we've done this hand in hand with fighting for convictions in violent cases, including cases where the courts have sent them back. My job is to make sure that justice is served, and I think it's clear that some of your maybe more conservative colleagues believe that I have leaned too heavily on correcting the wrongs of the past. My office has been measured, it's been transparent, and I've listened to the community, and I've relied on data to inform our policies. My policies haven't been dogmatic. When faced with a global pandemic and a nationwide spike in violent crime, we reconsidered our position on the multiple bill, and we have been applying it on violent offenders. When faced with juveniles planning and carrying out violent crimes, we've reconsidered the juvenile transfer law. Listening to community to deliver. But at the end of the day, it does not work if people don't trust the system. It does not work if communities don't trust the prosecutor. We've gotten to a place now in the city of New Orleans where people do trust the system. They do trust the prosecutor, and they're coming to court and they're playing their role in public safety, being the change they seek, testifying in court against the bad guys because they know we want to get it right. And when we find the right person, we're going to make sure they have a fair trial.
Thank you, Mr. DA. And I know we've already passed the 1 o'clock hour. I want to thank you again for being here today voluntarily. I want to thank Chairman for allowing me to be a part of this this conversation. My hope is that as this goes forward and that this legislature continues to do its work, that we keep in mind the fact that this is valuable time and resources that we're pulling away from the district attorney's office being able to actually do the job that they were elected to do. And that's important. Let's not lose sight of that. Because every second, every minute, every hour that we're dedicated, that we're focused on what I believe is in a lot of ways misguided attempt to push an agenda, we're getting away from the opportunity to make our community safer. To make our community safer. Thank you.
Thank you, Senator Plessis. I thought we were close, but Senator Abraham.
Yeah, I'm going to kind of maybe wrap it up. First of all, just state from me, and I believe I speak for the committee, there's no political agenda here at all, okay? I want to just state that very clearly. Second, evidently you are doing a lot of good programs that Senator Duplessis asked you about, and evidently they are good, okay? But you know, I have a saying that the good is the enemy of the best, right? The good is the enemy of the best. So what does that mean? For all the good things, we want to be the best. So when we see from these last 3.5 hours, when we see all these cases in the last 6 months that I believe are abnormal, from just a number standpoint are abnormal, then we have to address it. We have to say, well, look, that's not making it the best. Maybe there's something we can correct here. And that's why we're here, to make it the best, not just good. And so you made a statement that in the past, in your administration, you don't think there's any more, I think you said it, that there's not any more post-conviction relief cases that you've done the last 2 or 3 years as of the last 6 months. I think you might have said it, but I want to see the evidence of that. To me, it seems like there's a lot, and that's why we're having this hearing, because people still don't like criminals being out. That's a big, for all the good that you can do, that one thing can raise it up where people have a negative opinion of what's going on. So that, again, that's why we're here. So it was pretty overwhelming evidence to me. There was a lot of things going on the first 6 months of this year. Maybe the information we're going to receive from you is going to refute that. I don't know, but that's what we want to see. And if there's other cases, I want you to show us that no, that the same amount was going on the last couple of years as it was the last 6 months. That's the only way we can tell what's going on in this post-conviction relief situation.
Senator Abraham, I like that phrase. I'll probably steal that and use it. I think it's a good principle. And I'll tell you, I am first and foremost, I'm a citizen of New Orleans, but I'm a father, and I'm a husband, and I'm a mother. I mean, I'm a son, right? Thinking about my mom because we were the victims of crime. So I've seen this thing from a lot of different angles, from the barrel of a gun, from the prosecutor's table as a judge. I've looked at it from a lot of different perspectives. And, look, I think you all looking at every single thing that has occurred, that's a good thing. Sunshine ain't going to hurt anything.
Yeah.
Sunshine's going to expose a lot of things that I don't think have been exposed yet. And I would just encourage this body, as we were looking at Orleans Parish, to also look at the number of these types of cases that occurred under the last administration in Orleans Parish and in the administration before that and the administration before that, because New Orleans is a little bit different. And I think it's really important that you look at things not just in a vacuum, but look at things from the totality of all of it. And I look forward to sharing information with you and having more conversations with you. But if any of you are willing together or individually to come to Orleans Parish, to come to court, to see and hear what juries are saying when we're trying to pick one, I think it would be very informative.
No, I appreciate that. And I do not think this is a waste of time. I think this is an important time. Different from my colleague here, and that's why I think we're here, and that's why I think that the public that sees this will believe that this is a good use of time. Anyway, that's it. Thank you, Mr. Chairman.
Thank you. And I believe that the victims of people who were released will have something to say about this, who are released and committed crime that could have been prevented by their not being released. But be that as it may, I do thank you for your testimony. Your reputation precedes you as being a very smooth talker, and you did not let me down. And you're very smart, very articulate, and I appreciate your voluntarily coming, and we'll just have to see where this information we get leads us. But I'm going to move on to public testimony. Thank you for coming. I got to move on to public testimony. I'm going to invoke the 3-minute rule unless there's an objection from the committee. Bruce Riley, is Bruce here? Okay. I want to get it moving. I know people have other hearings to go to.
Another round of edits on the thing.
Oh, really? Still going on?
Yeah, another one. They sit back.
We're leaving that, let's go to the door so we can get with the public.
Thought about it. Another group
For the Super Bowl? That'd be great.
But I remember at the end of my stint, I was the feeling was mutual that I would never be coming to work for him. And it wasn't because of anything necessarily like, I just
We got Mr. Riley at the table also. If you'll approach the table, Claude Michael Como, if you're still here. Is Mr. Como here?
One second. Let me check with side.
Okay, I think they went to grab somebody. And Hardell Ward. Okay, gentlemen, if you'll introduce yourself. I'm sorry, but other people are about to leave, and so I'm trying to get everybody in. I'm going to limit you each to 3 minutes. So, Bruce, since you're a regular, why don't you start us off?
Thank you, Mr. Chair, members of the committee. Bruce Riley with Vote. Obviously, a lot was said, so I'm just going to try to keep it to a couple of points here. And just getting back to the challenge of going through post-conviction to get your merits heard. You know, most people who get convicted and then they deal with their direct appeal, the real merits of what went wrong in your case are not eligible to be reviewed. So the direct appeal barely ever gets somebody out. And then the folks that are then left unto their own devices to try to get into court, many of these cases that we're just talking about are oftentimes people who struggle with literacy. They may struggle with language barriers. They struggle with education levels. And I helped plenty of people work on petitions while I was incarcerated and I was serving as a jailhouse lawyer. And I had to learn the law myself. So they were relying on someone who didn't even have a law degree to do their best. And then I wasn't even allowed to go into court and explain the things that I learned. They had to then go into court and try to say, Your Honor, this is the situation. And just as was said, hardly any of those cases get through the procedural bars, and you don't even get your merits heard. And so we hear about these stories around the country, including disproportionately here in Louisiana, people who get their convictions finally looked at and overturned, and it's after 20 years, 30 years, even 40 years. And you know what? They could have done that after 20 minutes, 30 minutes, 40 minutes, but because of procedural bars, they never got to the merits. So it's disingenuous to say, this has been ruled on time and again. The reality is, when D.A. Williams is talking about these cases, many of them never have looked at the merits ever. And then going back to everyone says that they're not guilty or whatever, they're all this and that, 95% or more cases are guilty pleas. So we're only talking about a very narrow section of people who disputed their guilt, who then are still disputing their guilt decades later. That's like a tiny fraction of people. And for us to be unwilling to look deeply at those cases, including non-unanimous jury cases, where, in this state...
Over half the cases we reviewed were guilty pleas, by the way.
Yeah. So, and the thing is, as we just heard, people are getting convinced to be pled guilty to crimes. And you're being threatened with, you're going to get life if you don't plead to this, on and on. You're going to get the death penalty if you don't plead to this. If you plead to this, we'll give you parole after 10 years, 6 months. If you go to trial and you lose, you're getting the chair. Well, what does your mama tell you to do? Your mama's going to say, take the 10-6 opportunity. And then you know what? 9 years into it, they say, yeah, we're not doing the 10-6 anymore. And then you're still there 40 years later. That's why this body had to pass a law to look at these 1970s lifers, because it was unjust. And when you sign a guilty plea, that's a contract. You're entitled to the customs and the norms if it's not explicitly said in the contract. And so a lot of people who had parole eligibility had that rug taken out from under them, and so they never even get a chance to see the parole board. So there's a lot of things that weren't said based on this idea that we have this perfect system that's just chugging along, and now Jason Williams is disrupting this perfection. If we think, considering everything around children being given mandatory life sentences, non-unanimous juries, police misconduct, Brady violations, Batson, where you could manipulate who's on the jury, all the way up to 1986, I believe it was, Crawford, where you can introduce hearsay evidence up till about 2004. This idea of getting a clean, smooth system is actually kind of new. And yet you got people who've been locked up since the 70s, the 80s, the 90s, 2000s. And the idea that the predecessors of Jason Williams were just squeaky clean. Harry Connick admitted to the U.S. Supreme Court he hadn't read a Supreme Court case since law school.
Okay, thank you, Mr. Riley.
I'll leave it at that.
I'm going to
Thank
stick
you.
to the chair's rule. Appreciate you. Mr. Claude Michael Como.
Como.
Oh, okay. I see that. Go ahead.
So my name is Claude Michael Como. I'm a staff attorney at the Promise of Justice Initiative. I was going to talk about non-unanimous juries convictions in relation to what we're talking about here today. So here today, we know how egregiously wrong non-unanimous jury convictions were. It's a system designed to fast-track black convictions, silence the voices of black jurors in order to do that. And I think in relation to what we're talking about today, it's important to know how long that law lingered in Louisiana. It was propagated into the Louisiana Constitution in 1898, and it wasn't until 2020 until the United States Supreme Court said, hey, you got to cut it out. Up until that time, it's not like the U.S. Supreme Court was just like, hey, I just found about this issue in Louisiana. People had been fighting that issue constantly and running up against appellate courts that told them they weren't claiming anything that was wrong. It was just fine. All the leaders in Louisiana were telling the people that were saying they had suffered a constitutional violation that their conviction was fine. And it wasn't until, the U.S. Supreme Court says, hey, you need to stop doing that, is when it then became apparent to Louisiana and the appellate courts that had been constantly denying applications that it was not fine, that it was an unconstitutional issue. So after that, I just want to restate some misstatements that have been raised here. Whenever Reddick came down, that was the decision from the Louisiana Supreme Court that said that they weren't going to issue retroactivity. That was because they said they could not. They said that it was on this legislature to make that change to go retroactively. But they did not prohibit DAs from reaching a different conclusion. They explicitly actually said that they could. They said that we note, without commenting on its validity, that the legislature has granted district attorneys with judicial approval to authority to agree to individualized relief. At that time, they're talking about 930.10, and then the AG challenged that law too. So in response to that, the Supreme Court said that with or without any legislation, the Louisiana Constitution, at Article 5, Section 26, provides the DA absolute discretion to not oppose or even join an application for post-conviction relief. And a lot's been said today about the need for adversarial hearings. But in that same decision, they say, in short, our decision does not mandate that collateral review of criminal convictions be unnecessarily adversarial, nor does it serve as a bar to cooperation between parties in post-conviction proceedings to achieve the ends of justice. So I think when we're talking about philosophical differences, we need to talk about which party has that philosophical difference, because the Louisiana Constitution seems to provide that district attorneys should be seeking out justice and not convictions, or defending convictions that they know that can't stand. Thank you.
Thank you, Mr. Como. And you are Mr. Ward.
Yes, good afternoon. My name is Hardell Ward. I'm the Community Impact Director at Promise of Justice. I want to first clarify some of the information that was stated today. The document that A.G. Burrell put of the stages is what we call the 9 boxes, sometimes 11 boxes, how you talk about it. As Bruce alluded, you don't get a chance to bring those claims with counsel, but 2 of those boxes. The rest of those steps, individuals have to do that without counsel, without a right of counsel. Usually they'll either have to do it pro se on their own, based on their own understanding of the law, or with inmate sub-counsel. Part of the reason why New Orleans has such a high incidence is because there are resources there, and there are attorneys like myself who are there, who are in that city, who are able to get access to those records to review those cases and bring. It is nothing more than New Orleans is the seat of this state, and it does have the resources, and that is where organizations like myself, IPNO, and others are placed. Second, the issue of CRD is unusual. It is not. Before I was community director, I was the managing attorney of the Jim Crow Jury Project. In doing that work, I traveled to every parish in the state. I have met with pretty much every DA. If I haven't met with them, I've emailed or communicated by phone. The CRD is novel only in name. Jefferson Parish has the CID, the Conviction Integrity Department, which is staffed by a former AG, that is doing the exact same purpose. Justice. EBR doesn't have a division in that name, but when I met with them, they had a specific first AD, the chief of appeals who we spoke to, and other members of the staff. Shreveport made available their first AD, and the DA themselves to review cases. Many of the districts in the state, the DAs went through every case with me, and we reviewed every single non-unanimous jury case. And each of those DAs made their decision of whether or not they believe relief can be granted. This is how the process has always been done. What is new now is Bayou Mama Bears or whatever groups specifically targeting New Orleans because the numbers are so high. To Mr. McGeeh's question of what about the numbers, so many? As Royce Plessis stated, there was 2,700 instances of multiple bill, and and you'll see the information, in 2017, New Orleans was the wrongful conviction capital of the world, of the nation, or maybe of the nation, I don't know if this is the world. Of course it would lie in New Orleans. Of course that's with the numbers. But it shouldn't surprise you, for I know some of your districts, many of your DAs resolved all of their non-unanimous jury cases within the first 2 years and granted relief. So while it may be 350 seems like a lot, the percentage of cases that were eligible is actually lower than other districts throughout the country. I think that's important to realize. We're focusing on New Orleans only because New Orleans is more public with it, even though they're accused of not being transparent. And New Orleans is considered of doing more when these same issues abound. Many DAs, as DA said about potential Brady issue and potential exposure, that is the exact reason many DAs have told me why they can't move forward, why they can't have a public process. This board wants an open record to review the records. That is exactly what we've asked for repeatedly to this legislature for non-unanimous jury convictions. Let us review. That is why we've asked for a motion for new trials, so that there will be an adversarial process to actually determine guilt or innocence, rather than us simply picking and choosing and allowing different fact patterns to reach it and decide what they want to do. If we're going to look at post-conviction relief, we need to be honest with ourselves that this is a common practice, and a practice that breeds faith in our citizens to know that cases will be reviewed, then that innocent people will not be locked up. If we're going to focus on crime, as Mr.
We've let you go about almost 4 minutes.
Oh, I apologize. I don't see the time.
That's okay. But we're also concerned about the guilty people, and out of the cases that we've reviewed so far, none of them were factually innocent. They don't even claim to be factually innocent. But anyway, thank you all for your testimony.
Can I respond to it? No?
I'm going to call up 3 more. I've got Norris Henderson, Jim Boren, and Rebecca Brumfield. Rebecca Brumfield waves. We got Norris Henderson and Jim Boren. Are y'all here? The anteroom is cleared out. Okay.
I think Attorney Boren was in
Oh,
the
okay.
hallway.
You're Mr. Boren?
No, I'm Mr. Henderson.
Oh, Mr. Henderson. Okay.
And I'm kind of confused, really, because when I came, I drove all the way up here, and I thought this conversation was going to be about one thing, and it started morphing into something else. But anyway, District Attorney Williams was talking about trust and confidence in the system. 24 years ago, my son and my daughter-in-law was killed. And my belief, it could have been prevented, because my daughter-in-law complained to the police department that her ex-boyfriend was stalking her. They dismissed it. 2 months later, he set her car on fire. They dismissed it. Mardi Gras of 2000, he killed both of them in front of her mom. And then the police realized that, wait a minute, this little girl was telling us the truth. Fast forward, in 2022, my brother was killed in road rage. A guy hit his car, jumped out the car, and shot him. That district attorney's office, victim assistance program, walked me through that whole process. That didn't happen when my son got killed. That didn't even exist. So when we talk about trust, how people show up, that's how people trust up. Bruce mentioned, I've been hearing all this about adversarial process. This is supposed to be a truth-seeking process. Bringing people to trial is supposed to be trying to find the truth, not kill my dog, I'm going to kill your cat. And that's all I heard today, is folks just trying to one-up the next person. I think to be fair in this whole process is that we have to look at the laws that this body has created. In 1990, That's when all this post-conviction stuff started. But it started primarily because when the Louisiana Supreme Court made DA files and police reports public records, and people started applying and getting them and finding out they was in prison for something they didn't do, this body changed Title 44, public records, that folks who were in prison were deemed to be non-persons when it came to public records. So when we talking about being fair, being transparent, we got to start looking in the mirror, because we kind of like contribute to where we at today. And I was glad most folks was talking about post-conviction, and they kept admitting that. The first thing I told my law clerks, let's see, can we procedurally bar them? And if anybody look at a post-conviction application, the first 3 questions past your name is give me the date that your appeal was final. They don't look to go to the merits of a case. So when you see these cases coming back years later, that's what it's about. And I'm going to share my case. I went to prison when police reports wasn't public record. 19 years into my prison sentence, they found out the victim identified somebody who was already in prison. Thank you.
Thank you, Mr. Henderson. Okay. Mr. Bourne apparently has left. He is not here. On the agenda, we're to talk about the task force. We're not going to create a task force per se. We have to be in session. However, we do have volunteers to assist us in analyzing all the documents that we anticipate receiving from District Attorney Williams, and they've all agreed to it. Among those are Representative Villio, who we heard from earlier. District Attorney Tony Clayton is agreed to be on that. District Attorney Colin Sims, St. Tammany Parish, is agreeable to being on that, and his appellate attorney, Matt Kaplan, is also going to assist us in analyzing all these cases. And lastly, Chris Walters with the governor's office is going to assist us in that. Does anybody on the committee have any objection to that? Hear no objection. Thank you. I think we are done with our business. I want to thank everybody for coming. Appreciate the opportunity and all the witnesses who have come. And
The minutes from that last meeting.
I did it. Yeah, did it first thing. Anyway, so we are good. Motion to adjourn by Senator Abraham. There being no objection, we will be adjourned.